following podcast contains opinion and commentary protected under the First Amendment and fair use, as well as public records and freedom of information laws. The content may include adult themes, adult concepts, and adult language not suitable for all audiences. For the safety of all, no viewer should ever engage with, interact with, seek out, or contact in any way persons being discussed, including those under criminal prosecution, and especially those that state,
"It's not like I've gone and killed somebody!"
Viewer discretion is advised.
Step inside, take a seat, let the stories feed your soul. Hear the echoes, find the patterns, every truth, each hidden role. From the bench to the whispers, where the gavel takes its toll. There's a rhythm in the verdict, echoes from the cubby hole. Echoes, echoes from the cubby hole, where justice swings and stories unfold. Echoes, echoes, feed your soul. We're talking truth from the cubby hole.
My meat.
Honk my meat.
Okay.
Honk my meat.
Honk. Honk my meat.
There you go.
Welcome, everyone, back to my channel. Well, welcome back to your favorite cubbyhole on the internet. Gosh, I can't remember which order I say things in anymore. Happy honking Sunday, everyone. Honk my meat, as they have all said. It is the running joke of the community, I swear. And what a good joke it is. What a good joke it is. I was hoping to have that longer. Maybe I'll have to re-edit that whole little thing and make it last a couple minutes with some music. I don't know. It's good to see you all here. Thanks for joining me. Nice to see you, Danny and Henrietta and Ms. Wings and Wallace. And let's see, Michelle and let's see who else. Even Bruce the Moose. Good evening to all of you. And hopefully your weather is as pleasant as it has been here in the lovely upper left. So, oh my God. You know, I'm by myself because someone's late. Someone had to go do an event and then go do dinner afterwards with some other people. So the party of the second part is not here yet, as is typical. But that's okay. We've got so much to read through. We'll be fine until he decides to grace the rest of the internet with his presence. It's as so many of you demand of him these days. And yes, we are talking about the one and only Jeep Daddy. Or is it Jeep Zaddy? Has there been an official change yet? I do not know. I call him Hey You. Sometimes, you know, I get daggers for looks when I call him the wrong thing sometimes. And just ignore any background noise. It is warm enough today, and there's enough sunshine around here where we have had to turn on some air-moving equipment, so that'll manifest as low-level background noise until such time as this channel grows to such epic proportions where we have silent air conditioning as opposed to non-silent air conditioning, or in the case of this time of year, cheap window fans. So just ignore it. It's fine. You know, I could just let it run without me speaking. It could be sort of ASMR, white noise, just a little bit of shh in your background, so that when you get tired of all this nonsense we call Laura Owens and David Gingras, you could have something to sleep to. I mean, that would be soothing, wouldn't it? Wouldn't that be so refreshing after all the squawking and all the complaining and all the whining and all the groveling and the grovelly voices? Well, the vocal fry voices.
It's douche canoe and pregnancy faker.
Yeah, we are indeed talking about douche canoe and pregnancy faker. They just can't keep themselves out of the crosshairs of the legal system, of the criminal justice system, and the Arizona State Bar. Yes, that's right. The Arizona State Bar is having a field day. And I saw some comments. Some people were asking, so did the presiding disciplinary judge actually make an order? Yes, they did. We read it. So please do, people, pay attention. I'm not reading these things for my health. My doctor would prefer I don't. You know, because all this nonsense between Laura Owens, however many years and or decades of engaging in, shall we say, fraudulent behavior, in our opinion, and David Gingras being a sleazebag of an attorney. Yes, he is the douche canoe for a reason.
The fucking douche canoe.
We may cover some history there. We'll see how the evening goes. I've got some of his past queued up too. And I mean video. I don't just mean, some of the old documents from days gone by where he was being criminally pursued for, sex with a minor. Yeah, we know how that ends. Or in the case of the alleged victim, how it didn't end because he didn't end up getting prosecuted. They let him off the hook. But, there's other things out there like, representing less than savory sorts of people in the name of free speech and the First Amendment. Or at least that's what he claims, except when he doesn't claim that. And then he claims that harassment is free speech, except when it isn't for Laura Owens. And we've even got a little bit of Nick Rekieta and Megan Fox roasting them for, let's see, how many hours is it? 5.5 plus 4 for 9.5 hours. 9.5 hours. Nick Rekieta on Rekieta Law, the YouTube channel, with Megan Fox, the one and only Megan Fox. Yes, not that one. You know the one we're talking about. The one who writes very thoughtful, very thorough articles. That Megan Fox, they spend 9 hours in the wee hours of the East Coast and Central time zones talking about the injunction against harassment of Hey Rob. We have covered that already. They covered the ex parte hearing with Laura Owens and Commissioner, I think it's Lindsay Coates, if I'm remembering names correctly. They talk about that, and then they talk about the first half of the injunction hearing with Hey Rob and his, I'll be nice, lackluster attorney. They say some not so nice things. I'll be a little bit nice because, it's Sunday. We're supposed to be a little bit sanctified on Sunday, or at least so certain Western religions tell us. But they let him have it. They even let Douche Canoe have it. The roasting from Megan and Nick are epic, are absolutely epic. And I highly encourage. I didn't include that as a link here because it's just so enormous. I've got so many sources tonight. I thought I was cluttering up the show notes. So by all means, go over to Rekieta Law. Check out. It will keep your day busy. If you do things with your hands, and that's how you get through the day, get those earbuds charged, get those AirPods going. You may just want to plug them in because 9.5 hours, folks, is a very long time to be talking about Laura Owens, David Gingras, and sadly, Hey Rob. And while I haven't been very good at supporting Rob's funding cause, I was floored. I was floored at his horrific representation, costing him $31,000, according to Megan Fox. I was horrified that absolutely abysmal defense representation cost him that much money. It was a good thing that, I was in my car. Thankfully, I'm a sensible driver. It makes you want to drive your car off the road. It's just so nonsensical. It was horrible. It was horrible. And what was more horrible, and I'll summarize just a little bit, was because Nick is an attorney. Yes, Nick has gone through his own little, shall we say, midnight of the soul in his personal life. That, took some tolls on his YouTube channel and so forth. Despite all that, he has had some very salient, very important, and very critical analyses about how much, not only did Douche Canoe get all of his claims wrong being a First Amendment attorney, and he says he's going to clip some of David and send it to Mark Randazza, who is currently representing David Gingras in a limited capacity for his Arizona bar trials and tribulations and, and whatever else. I hope Nick does it. I hope it happens. I hope he sent something to Mark Randazza, and I wonder if could that turn into something. I don't know. I had a good guffaw. I very much enjoyed it. You can. I know Nick is sort of the person that some people take it or leave it. I have to weigh him in limited quantities. Quite honestly, not because of what he says. He's hysterical. He's very entertaining. He has interesting points of law. Generally thinking, I think he's accurate. He reminds me a little too much of X number B in my past, right down to some of the problems in the personal life and with, shall we say, substance uses. Well, actually, my X number B. Oh my God, as opposed to X number A. It just occurred to me. My X number A does start with an A, and X number B does start with a B. So I'm going to have to be careful if there's ever a C that waltzes into my love life. I'm going to have to nip that in the bud. I don't need an X number C too. My God. But anyhow, Nick goes over some good points. And one of the things that Nick comes down to as they kind of get to the end of the hearing and all that is there's a lot of appealable issues here. A lot. And because of how much Hey Rob's attorney soaked him for that horrifically unprepared and abysmal representation, there was no funding to even think about appeal, supposedly, allegedly. I don't know that factually. That was sort of what Megan was intimating. Megan had some more stuff from Rob that she was not sharing visually, but discussing orally, as opposed to, blowjob babies. But my God, that man deserves some more money to go fight this. Just because he deserved better than what he got for his injunction hearing. He sure as hell didn't get 30 grand worth of representation. That's for damn sure. Oh my Lord in heaven. So yes, I got my dander up. I listened to those 2 episodes, all 9.5 hours back to back through the weekend on a slightly faster speed to try and catch up because so many people are talking about this now. It's difficult to keep up. Everyone's talking about it. Bacon Bears is doing excellent. There's others. I love Bacon. She cracks me up. There are so many people talking about these stories. So many. Oh, let's see. I'm going to check in for chat just for a second. Hi, chat. Happy Sunday, chat. I see Wallace. I see Bruce. Oh, Cracked Pepper, MDLY. Yay, made it. Hello, amazing chat and echoes. Hello, Cracked Pepper. Welcome. Let's see, Michelle. I yelled honk my meat while laying on the horn at some NFL draft out of towner that almost hit me this weekend. My niece looked confused. Oh, that's brilliant, Michelle. Brilliant. I can't endorse those things legally necessarily, but brilliant. Big Bad Marcus, good afternoon and evening. That's probably evening on your side of the world, sir. Good evening. Hey, honey bunnies. Careful. You might make other people jealous. And good evening to cousin Alex in the chat. Nice to see you, Alex. It's been a little while. IB is here. Hi, IB. Let's see, Cracked Pepper also says, I know, and I've got the chats on the side too, just because I left them on from the game stream yesterday, but let's see, Cracked Pepper says, I can't explain how amazing it's been as someone who wakes every hour and half hour every night to get to listen to them each time. It's sweet hours. Yes, there's so much going on, isn't there? And ignore my allergies. They will irritate me. They will do all kinds of things to my eyes as I rub things and sneeze and cough and do all the things that bad genetics have given me. But we deal with it because this is an important story. So I will suffer. To keep talking about this story until justice is rightfully served on all counts. And I know I'm not alone there. See, cousin Alex says, anyone want to see a real ultrasound? I have one. Correct name, placement, and all. Oh my goodness. Where's my buttons? Cousin Alex made an announcement, everybody. Wow. Real babies, folks. And cousin Alex has the ultrasound to prove it. Isn't that amazing? Congratulations, cousin Alex. Congratulations to you and your significant other, your mans. Boy, you didn't waste any time. But bum. Ricada did stuff with his hands live. Well, he does. He does do things with his hands. Let's see, Marcus says, total aside, but did we get the last episode of Love Trapped, or was it extended? Love Trapped is going to, I believe, 12 episodes now. So we should get 2 more and whatever extra snippets they decide to give it to us. Yeah. Yes, Henrietta's got it. There will be a total of 12, plus whatever bonus additions. PCB Amy, hi Amy. I'm late, but did I just hear 30,000 for that sorry excuse of an attorney? Wow. I watched some of Nick and Megan last night, but fell asleep in the end. Yes, $31,000 according to Megan Fox, who had the receipts in her hot little hands, or on her screen rather. I couldn't believe it. That probably pissed me off maybe more than some of the other stuff, other than Nick saying there's an appeal case here. There's an appeal to be won, and it hasn't happened, and it won't happen with that unfortunate situation of representation. And Megan made a plea to anybody in the Phoenix area who could maybe represent Rob on appeal and get this thing kicked where it rightfully deserves. Between the semicolons would probably be a good place to kick that IAH. There was a lot. And it just, oh my God, my blood pressure was high listening to all that. I was just so irritated. So irritated by I was irritated the first time, but after hearing Nick go through it and say, why didn't the attorney say this? They should have done this. Not being a legal mind. I was halfway there. I think I even said some of the things that Nick, being a professional attorney, even hit on. I think I made some of those points in my going over this, over the IAH of Hey Rob. Oh my gosh. Oh, is Bacon Bears in the chat? Oh, where is it? Where? There's Bacon Bears. Bacon! Good to see you, madame. Happy Sunday. And I'm lonely. See, I should give Bacon Bears a link. Let's do it. Let's do a collab right now. Right the heck now. No, I don't know. I don't even know how to do that. Oh, that would be fun. I hope Bacon Bears does more lives because I'm hooked. She's brilliant. She's absolutely brilliant. And I can't get enough. And who doesn't like bacon? I mean, just by substance, if not name. Oh my gosh. Yeah, so much good stuff. All right. So, in good fashion, because Jeep Daddy is late in his usual self, I'm stalling a little bit, but we're going to get going. We're going to get going on this stuff because we've got pages upon pages, and we'll save some of the entertaining things for Jeep Daddy to agonize over because, well, that's why he's here. He is the the punching bag in the metaphoric sense, of course. So let's see. All right. Now let's go over to some things. Let's see. Have we hit all the buttons? Yes, we have. So let's talk about the latest things in the Twitterverse. At Clayton's Justice, that being victims for seeking justice for all victims of Laura Owens. They've been busy. There's lots of stuff to cover on the Twitters. So here's the latest thing in the Owens verse as we sort of culminate all of last week. I know. I should have done something midweek. I would have been a little bit better off. Oh, Bacon Bears. Oh, you dear sweetie. Thank you for the $4 super sticker. You are amazing. You are awesome. Thank you so much. I'm still learning how to get all that stuff. I'm waiting for YouTube to send me things in the mail so that I can actually do something with all the generosity and kindness that people shower upon me in my tiny little cubbyhole here. I'm not kidding, folks. My walls are just out of frame. They're I'm the digital equivalent to Harry Potter living under the stairs. That's sort of how I equate all this, I can't live under the stairs because I need a little bit more of a direct metaphor. So I'm in my cubbyhole. I've got a little window over here and some stuff in it, and the walls are right over here. And then there's a little circular staircase over there. But never mind. It's just too much. And I'm feeling claustrophobic anytime I do a live because if I sneeze too hard, I'm going to blow over the backdrop behind me. Wouldn't it be great? I would love like a legitimate little studio room That would be fantastic. Maybe we'll get there someday. Maybe so. Okay, back to the Twitters. So we have a docket update. And this, I mean, if your dander isn't already roughed up already, I heard about this first from Rachel Juarez when she appeared with Reality Steve at the end. And that was the episode that last I checked, which was yesterday afternoon, is still unavailable. This was reported on by @Clayton's Justice Twitter, where that episode of Reality Steve reading his letters that went back and forth between him and Laura Owens, that video is not available currently. And at the end of that, Rachel Juarez pops in because she's just so amazing. I mean, Rachel Juarez is like Lauren or Bruce or Dave Neal. They just sort of poof, sort of like Beetlejuice. You don't even have to say their name. They just kind of show up magically. It's the strangest thing. Rachel Juarez talked about there being an extension, or was it on Lauren's live? Maybe I'm confusing the two. It could have been on Lauren's latest live with Clayton Echard, Stephanie Young, and the amazing Rachel Juarez. Well, they're all amazing. Can we just say that? I think we can, can't we? They're all amazing. There are so many amazing people. They're either victims or they're talking about this. It's sad, really. We have to have amazing victims and amazing people talking about it. At any rate, Rachel had communicated that Laura's attempt to get an appeal in the Owens v. Maricini case, we all know that as the DVRO, the domestic violence restraining order that Laura Owens just couldn't be bothered to show up to the first time. Or the second time, for that matter. We E'd it in. We digitally phoned it in. We zoomed it in from the car, dressed in our writing gear, our white turtlenecky thing and vest. Oh, Your Honor, I'm so deathly ill. I'm bleeding out of all of my orifices. I just can't come to court. I need special ADA accommodation. She was at a horse show. We know this. I reported on it like within 2 hours of that information dropping because it was getting shared around quickly. And I caught the original Instagram image of Laura Owens accepting an award at that horse show when her ass was supposed to be in San Francisco. I had that, as did Megan. I went back and I found the original Instagram before the horse show people yanked it. I'm sure because Laura Owens is like, there's these people harassing me. Oh, you need to take it down. I'm being harassed. Ah! Maybe I should have Devil Laura Owens queued up too. Oh, that could work.
You need to take down the pictures of me winning horse awards. I can't stand the harassment by Hey Rob and everyone in the Justice for Clayton cult.
Oh my gosh. Can you imagine? Can you imagine being harangued by that woman? Oh, you take my pictures down.
Take my pictures down now, or I'll sue you with an injunction for harassment.
I don't know how she does it. Yes, see, like I told Bacon Bears, I've got buttons too. Sometimes when we read Laura Owens,
we want to read Laura Owens like this. Because, Your Honor, I want to have ex parte communications with everyone.
It's circumstantial. The voices are circumstantial. And it totally depends. It totally depends. Not defends. Depends. It totally depends on what sort of mood we need to read them in. I think there's at least a couple different personalities we have to read Laura Owens in. That's just the way it is. Oh, golly Moses. So, okay, back to this. We're talking about Maricini. So Laura Owens filed for an extension. Rachel Juarez talked about this. It must have been on Lauren's Live. That's where I was going. It must have been because they talked about this is not uncommon. They're usually granted. An extension is an extension. I sort of snickered when Rachel mentioned it. I snickered because, yeah, it's probably because David's too busy fighting with the bar to ghostwrite her appellate brief for her. That's my opinion because, in my opinion, David Gingras is more than a little involved in any of her pro se writings, in my not so humble opinion. Now, again, I could be wrong. Maybe somehow Laura Owens has infused herself with some douche canoeiness of her own, and somehow it just comes out the same way he does. I think there could be a lot of discovery to that effect if people aren't spoliating evidence off their computers, which that wouldn't surprise me either. Douche canoes and sleaze bags and people of that ilk, they try to cover their tracks. Sometimes they win, sometimes they lose, sometimes they fail, sometimes they cover their tracks. These are just my opinions, though. I think he's a douche canoe. I think he's a scumbag. I think he's a sleazebag. He's less fun than a bag of dicks, really, is really the whole thing. Or as Bruce the Moose is saying, canoeiness. Yeah, that works. That works. Fair enough, Bruce. That'll do for a Sunday. We've got a full tankard of water. We're ready to go. So, yeah, here it is on the docket. Let's just read what it says. Docket update for the DVRO appeal of hashtag Laura Michelle Owens v. Mike Maricini. Laura has filed a request for an extension of time, requesting 62 more days. That's an interesting, specific choice of number of days. 62 days. I wonder how they choose that number. Mind you, this liar and scammer filed her notice of appeal back on 12/4/2025. Yeah. So we're getting close to the half-year mark already. Absolutely pathetic. I agree, Clayton's Justice. Mike wants nothing to do with this woman, yet she continues to try to weaponize the legal system against him. Hey, Laura. Hey, girl, hey. He's just not that into you. Get a life. Bruce also says DSG is rude and boatless. Well, maybe we could set him up with maybe we should get him a life raft. He might need it. Or maybe some lifesavers. I can afford him a little roll of lifesavers. He might need them. That's candy. It's not an insinuation. Oh my goodness. It's like a free ride, Bruce says, when you've already paid. What? Is this because Hi, E-Broccoli. Bruce, ironic to be a douche canoe when you have no boat. Well, he's paddling up Schitt's Creek as fast as he can. He sure is. My God. And he's trying to get Mark Randazza to help him, which may not go so well for either of them, but who am I to say otherwise? Oh, my goodness. Ms. Wing says he's cool, has new AC. A dinghy for Jingy. You guys are funny in chat. You're hysterical. Oh. So let's see. Appellate's a requested extension of time. Appellate's opening brief requested for 6/29/26 by 62 days. And it will most likely be granted. Okay. So that's item number 1. Check. Next, go to item number 2. Item number 2. Let's go over here. These are not necessarily in any sort of order. Just so you know, it's fair warning. I just plucked them into my little notepad and plucked them right back out. So these could be non-chronological. Forgive me for that. For those of you, what's chromatically? No, chronologically assorted, organized people. Yeah, that. And this is another one from our same favorite Twitter person. I think I know who it is. I've got a pretty good idea. Pregnancy scammer hashtag Laura Michelle Owens gave her now infamous TEDx talk on December 4, 2021, and was sponsored. I knew this. I kind of covered it, but sort of didn't. I was being distant. And was sponsored by the Mercer Island High School women. The parent organizer for this event is Clace Frederick Manby. The school website, TED.com? Yikes. Take 2. TED.com/TEDx/events/something. There's a link there. It takes you to some people. As memory serves, I found another web page affiliated with the school that I think is now gone. And it was one of the first daring things I did, talking about this case privately. Tried to reach out to one of the young ladies who's long since graduated high school, trying to get some information on how did this come about? How did you select Laura Owens? Was she just a pool and people picked her, or she was just on a lineup and you had no choice? How did that work? I had no response. So I just kind of left it alone, but I was sort of shocked that the locale of it's a little too close to home. Mercer Island High School, we'll keep reading the paragraph. Mercer Island High School has requested the removal of this TEDx talk, that being Laura Owens, featuring Laura Owens. Whoops, I got ahead of myself again. of this TEDx talk featuring Laura Owens, stating the school does not wish to be associated with her due to her documented civil and criminal history. Well, that would be the smartest thing a school district or a school could ever do. Claps for that. Yes. Yes, indeed. And that's enough. In 2023, the Maricopa County Family Court found Owens had submitted false claims, altered medical records, and perjured herself in a paternity case involving Clayton Eckert, resulting in a non-paternity ruling and more than $149,000 in fee awards, now exceeding $220,000 by my last count. Owens was later indicted in 2025 in Maricopa County on 14 felony counts, including fraudulent schemes, perjury, and identity theft, among other things. Her TEDx presentation references victim Mike Maricini, whose DVRO case was dismissed in 2025. School administrators, including the principal and IT director, have submitted takedown requests but cannot remove the content directly. At Manby, Laura Owens' TEDx needs to be removed. Reminder of TEDx guidelines and fact-checking. Oh, I have not read these before. This is very interesting to me. The TEDx guidelines are as follows. TEDx organizers are responsible for ensuring the accuracy of talks and adhering to content guidelines. If a TEDx talk contains misinformation or disinformation, ooh, it can lead to consequences, such as the talk being published with an editor's note, removed from search results, or even not published at all. That's a clumsy statement, but I'll let them have it. Fact-checking is a critical step to prevent the spread of inaccurate information, and TED provides guidelines and resources to assist organizers in this process. Oh, Bruce is being silly. Bruce says maybe Chase J. Jones went to high school there. Breaking news. Chase J. Jones did not go to high school at Mercer Island High School. No, not at all. Sorry, Bruce. Oh, let's see. Danger. No, there's no evidence of Chase J. Jones being at Mercer Island High School, but I still find it interesting. And perhaps it was to smear? No, that's not the right word. Rib Clayton, because he was, for I forget how long, short amount of time, a Seattle Seahawk. So I was wondering if perhaps the Chase J. Jones thing and using a Seattle P.O. box, which when I was in town a while back, I snooped out. It does sort of physically exist, and the business running it has had lots of problems with the state. It's a shady business, shall we say. Jeep Daddy and I are debating converging upon the city, suitably equipped, shall we say, for safety, and snooping it out a little bit closer. I did some high-level research. I've got some stuff saved in a folder about Chase J. Jones and that P.O. box and its location and stuff surrounding that business, as well as a full thing about the real Chase J. Jones, who is in fact a black, a former journalism student, and ironically, according to my last article, identifies as a trans person. So that was sort of an interesting trifecta in my last round of research into Chase J. Jones, above and beyond what Dave Neal covered. And I see IT Goatee Brad is in the chat. Hi, Brad. Good to see you. Happy Sunday evening, sir. Oh, let's see. What else is going on? SRS bans 24/7. Bruce. Bruce is being silly. E. Broccoli says, if Laura wanted to get it taken down, she'd be able to get it taken down. Well, Laura doesn't want it taken down, right? Laura wants to keep it up so she can smear and defame, right? Maricini, in my opinion, that's the only reason to keep it there. But I think with enough pressure on TEDx and, pointing to the current legal problems of one indicted, felony indicted Laura Owens. See, I almost said it again. I almost said it wrong. I keep wanting to call her an indicted felon. I just can't get it out of my head. Maybe she could end up an indicted felon soon. We don't know. If she gets convicted, she will be an indicted felon. She'll be a convicted felon at that point. I stand corrected by myself. Bruce is saying, I went to Chase J. Jones P.O. Box using Google Maps Street View. I did more than that. I did the get in my car and drive a few hours there view. Yeah, when I decided to brave the traffic. So, I don't like to drive into town much. I like to stay away. It's just, it's not because of the traffic. It's just too much craziness, too many homeless people. Things that happen with big cities these days. And after Jeep Daddy and I spent some time at ye old Pew Pew range, I was a lot more comfortable with the idea of having some protection. I've been thinking about it a lot, quite a lot lately. Oh, let's see. E. Broccoli says these P.O. Box companies are often sketchy. I have concerns. And this one was the sketchiest. They had a fly-by-night, slapped-together, awful web page that was not very secure. The web page is gone now. I was hoping it would still survive, and I could have Jeep Daddy do his IT security voodoo on it, and look under the tea leaves. No, read the tea leaves of the sourcing there. But the business has quite a history of being non-compliant with the state. I love state records. You can find out so many things about people, just about their businesses and their records. It's amazing. It's absolutely amazing what you can learn. Yeah, that particular business, which is kind of no longer existent, but kind of is, it also sort of shares a business owner with a guy claiming to do kind of aquaponics, but that business is folded. It's sketch. It's sketch all the way around. How Laura Owens found it, I can't even begin to imagine, as she was impersonating Chase J. Jones. I don't know. It's like, is there some sort of criminal network underground? It's like, if you need a P.O. box to, erroneously and fraudulently send filings to and from. What I will say about that service is they had a transcription email service. So they would take any physical mail that came into your box. They would what do you call that? They would transcribe it and send you an email of the contents of it. They would look at your mail, they would write it down and send it to you, so you don't even have to go there physically. It was one of those. So by all counts, assuming that any filings or any information from the court ever went back to the Chase J. Jones P.O. Box, it was for sure being examined, typed up, and emailed back to Laura Owens, because Dave Neal discovered that Chase J. Jones is Laura Owens. So yeah, it was a whole racket, the whole thing. Big Bad Marcus says, "Wait, what about Chase J. Jones? I didn't even know this was a real person being impersonated. I thought he was a work of fiction. There is a real Chase J. Jones. There is indeed. I've got it. I want to bring that story. I really should. I just need to get off my ass and do some live from the field reporting with Jeep Daddy. I don't want to do it by myself because it's in a sketchy part of town, and I do mean that. And I don't mean that just because it's overly diverse." Someone's going to call me racist. I'll just cancel myself now. I'll see myself out now. No, it's a part of town that has high levels of crime, and sometimes there's multi-ethnic crime. There's a lot of stuff. It's just in a rough part of town, and it's wise not to be down there without a drop of protection. It's just not wise to be down there without a drop. So, Jeep Daddy's a little more proficient in handling certain things for protection. And so we've got sort of the standing thing of eventually we'll get down there, we'll do a story. I bought some little wireless mic things like for recording on a phone, that kind of thing. So I want to do a little bit of field reporting and like kind of tie up that little bow before we get to the criminal trial. I just haven't got around to it. I am dealing with so much work crap that I get home and I'm exhausted. And it's like, I don't want to get in my car and drive all the way into town and all the way into that part of town and then have Jeep Daddy with me and have him be properly armed, shall we say, with suitable things, armed and protected. It would be a little bit more than pepper spray, Bruce, but, a little bit doesn't hurt you. And sadly, if I'm not mistaken, in this state, certain things like that, pepper spray, mace, for a little while, I even had a little zappy, Mr. Sparky. I learned that the state frowns on people having those on their person, even for personal protection. So it's like you may as well just go fully licensed and get the real deal. It's a weird thing. It's a weird thing in the state when you're in state lines. So it's like, Someone else I know has, they know what they're doing. They've got their licensing and they're all covered. And I can just make Jeep Daddy my bodyguard. I find that just fine. That's fine and dandy. So that's sort of where the head is. I've been trying to work on this story for months, and I just never get it done. That and there's just too much stuff to read here. There's just way too much stuff. Henrietta says, yes, there is an underground that will tell you that. Dark web. Oh, golly. Maybe Laura Owens has found it. I don't need it. Don't need it. Karaoke. I want to say karaoke. Karaoke? I know. Carol. Good to see you, Carol. Given that we know Gingras lies, I think it's possible he didn't notify the CA bar of his ongoing AZ bar problems. He is legally required. I wonder if we could verify he did the right thing. I would imagine that all you'd have to do is call the California State Bar and see if they know anything. Yeah. Because, as I clear my throat after swallowing too much water, there's something called reciprocity with state bars. Things kind of carry over. You get disciplined over here. That could equate to discipline over there. It could happen. If he gets disbarred, it should happen. But I see no problem with asking questions of the California bar what his status is if he's being investigated in California. I think the public, because he claims to operate in the public sphere, shall we say, it is incumbent on the public to know what his standing is with either state bar. So, yes. Let's see what else. Casey Jimmy, nice to see you, says to Henrietta, the other pregnancy fraud showed up on the Maricopa court docket. Dismissal was April. The case was entering its second year. Details not shown on docket. Oh, interesting. I don't watch the docket too much because I just get lost in it. Bruce says, I thought the dark web was located in Hoboken. I think only if you're Greg Woodnick and Greg Gillespie, I think. Long Beach, Washington? No. Long Beach, California? I don't know. Is it across the tracks? Definitely. It definitely is. Boring Tax Lady says, if I don't go, it says to me. Me echoes, if you don't go by yourself, I'm having the babies. Have them all you want. I've got an ironclad alibi. I cannot have babies. Ooh, I won't divulge any more than that. There will be no babies at my hand, folks. Not at all. Let's see, Gilgo and yeah. All the way to Gilgo Beach by way of Hoboken. And Diddy. Don't forget Diddy. Wallace says, carry permits are so wild to me as a Canadian. I know. I've heard Runkle talk about, I've listened to Runkle talk about that a little bit. And it's funny. I haven't listened to him talk too much about pew-pew things in Canada so much so, but I know he works in that avenue and I've heard him nerd out about it. So interesting differences between states and the states and Canada. No thanks, MK. Good to see you. It says he's the Kevin Costner to your Whitney Houston. Oh, I hope not. I didn't care for Kevin Costner so much. I just didn't. Okay. Let's see. Cracked Pepper also says the Cake Boss Bake Shop was in Hoboken. No. Really? Oh my God. And I got my youngest daughter's baptismal cake there. Oh my God. Okay, that's frightening. I hope it was good. I hope it was great cake. I mean, we always kind of swear by Costco cakes in this corner of the world for some reason, but I'm sure there is better. And also Wallace. Oh, Wallace, thank you for the 5 Canadian pesos. That's very generous. Thank you so much. Pesos for you before I put the phone on the nightstand and just listen. Early day tomorrow. Good night, friends. Say hi to Jeep Zaddy for me. I will, Wallace. Should he actually show up? The slacker. The slacker. See, has he texted me yet? No, he hasn't. He was supposed to give me updates because he went to an afternoon event and then there was dinner afterwards and he said, well, things are kind of slow. I'll let you know. And I should be on somewhere around 7:30. That being Pacific Standard Time, 10:30 to those of you on the Eastern seaboards. But is he here yet? No, it's well after the 10:45 on the Eastern time code and 7:45 on the Western time code. He's not here at all. Slacker. Slacker, chat, you have my permission to give him hell, should he actually waltz in. For all I know, he's lurking in chat and listening right now. And he'll have something very snarky and choice to say at some, awfully well-timed point in the evening. Cousin Alex says, just wanted to say, Echoes, I appreciate your humor and that you don't swear. Well, I not to let the cat out of the bag, Cousin Alex, but I do. I just try not to be overly gratuitous about it, because you want to use the zingers when they have the most zing. That's something I've learned as I've gotten older with humor. And last time I saw my father, when he decided to grace me with his presence from another time zone, said, wow, your humor's really improved since I last saw you. It's been years. My dad and I don't see each other a whole hell of a lot. But I do, I use some words, and, it's when you use them, not what. Yes. So, if you're going to be an immature teenager or 20-something and just F this and F that and F it loses its effect. You just start to water it down. So, use the right words at the right time. And who was it that said that? Was that Shakespeare? Oh, golly, I don't remember. Oh, let's see. PCB Amy is sending out the Jeep signal. Yes, please. Because that was why I did not do a live earlier this week. He's been out of town himself. The slacker. He has been out doing, I don't know what. He hasn't told me everything he's been doing the last week. But I did get some Jeep pictures, and there was a picture of his Jeep with mud all over it. So I do know that he has been doing Jeep things, as a matter of fact. I just don't know everything he's done yet. So there's probably going to be footage on his channel at Off-Road Entropy on the YouTubes, if he actually remembered to take footage of whatever the hell he was doing. I should go spy on him and see if he's done anything other than embarrass me. All right, let's see. Yes, it does. Yes, Cousin Alex says, yes, loses the effect. Yep. That's the whole point of swearing. You want it to be impactful and and if at all possible, hysterically funny. That takes lots of skill and reading the room. Okay, back over to this funny little thing, because I'm just sort of intrigued by the TEDx rules. TEDx fact-checking guidelines. Did I read this part or did I read the first part? No, I think I read the first part. What is fact-checking? Why does it matter? Well, we know what fact-checking is, right? Real consequences to the talks you produce, since people will often change their behavior based on a talk that they watch. So you want to be sure you are not accidentally sharing misinformation or disinformation on your TEDx stage. Who did that? Who shared Mr.
But that Michael Maricini was abusing me. He was doing things during sexy time, and they were abusive, Your Honor.
If Mike had more money, if Mike had a lot more money, with the criminal aspect of things with Laura Owens, and the devil is in the timing here. And I say that as someone who doesn't practice law in any capacity. The devil is in the timing. I think some people could go after Laura Owens, to use a metaphor, put all the nails in the coffin. And I think Mike Maricini would have just cause to go after her for defamation, pending, post criminal trial, because I think it's going to go to criminal trial. I hope it does. I really don't want it to be in the middle of sweaty summer in Arizona, the roasting in the Arizona desert. I'd rather prefer it be in the wintertime. Not that we want to see justice delayed, because justice delayed is justice denied. However, just because I'm being selfish. I'm being selfish and I want to be comfortable. I could still wear, well, I wouldn't dare wear jeans and a t-shirt in the courtroom, but you know what I mean. You want to be comfortable, right? And I'm sure the air conditioning is well serviced down there. Oh my gosh. Okay, so let's see. Leaving this TEDx up. This is more from @Clayton's Justice Twitter. Leaving this TEDx up continues to victimize Mike Maricini, perpetuates Laura Owens' lies, and goes against TEDx guidelines and fact-checking. @Chicken Soup for the Soul removed Owens' entry from their digital copies after her pregnancy scams were reported by mainstream media. Please do the same. And TEDx and TED Talks are tagged. And so if you were to go, ladies and gentlemen, let's see, does this take us anywhere? I'm just going to click on this. Oh, it does take us somewhere. Look at that. So this is the link at the top of that Twitter, and I'm just going to look at this here. This is about the TEDx Mercer Island High School Women event that happened years ago now. And we have the list of speakers. Let's see, the spirit of ideas as we're spreading. TEDx is a program of local, self-organized events that bring people together to share a TED-like experience. At a TEDx event, TED Talks, video, and live speakers combine to spark deep discussion and connection in a small group. These local self-organized events are branded TEDx, where X independently organized TED event. The TED conference provides general guidance for the TEDx program, but individual TEDx events are self-organized, subject to certain rules and regulations. So how in God's green earth did they dig up Laura Owens to produce that green-screened video of her defaming Mike Maricini? How did that happen? Inquiring minds would like to know. Was she on a roster of people to solicit for TEDx? Is there someone there that knows Laura Owens in Mercer Island somewhere? I would drive a few hours into the city to get on that interview post-haste, because inquiring minds want to know. There's going to have to be a little bit more research here, I think. Dear me. Let's see. So the list of speakers. Jesse Fink Freitag. You know what? I'll embiggen a little bit. Who is the director of marketing and ops at Live Bar and podcast host. And then a list of qualifications. Laura Owens, podcast host at Nobody Told Me, ! CEO. Oh, where's my, damn it, I still don't have a drum roll. CEO of Quartet Farms. See, look, folks. Boss Bay Bitch still says that she's the owner, CEO of Quartet Farms, even in a TEDx reference. Paging Queen Jennifer. Yes, I know Queen Jennifer, there's a pending stipulated dismissal for the bankruptcy, but here she is again claiming to be a CEO. Yet another example. Ding, ding, ding. Ding, ding. For Laura Owens, we'll just read this because it's about her. For Laura Owens, everything. Oh, golly, I feel like I need it. Oops. Oh, too big. That's Mercer Island. Where'd it go? Damn. Okay. Boy, when you jump the zoom in, sometimes it just goes crazy. Let's try that again. Let me try that in narrator voice. No, I won't push a button. I'll spare you. For Laura Owens, everything boils down to stories. Whether it's the stories we tell ourselves in order to succeed, the stories we tell each other to uplift and inspire, or the stories we share with the world, she's dedicated herself to capturing the human experience in a unique and lying way. The daughter of National Radio Hall of Famer Ron Owens and award-winning journalist Jan Black, Laura is committed to putting her own spin on the family tradition. Oh, yeah, she did. Oh, boy, she did. She put her spin to the tune of 14 felony indictments, folks. That's the unique spin she put on her family tradition. Doesn't say much about her family tradition, does it? Not so much. Not so much. Yikes. Okay, is that enough of that one? Let's see. Okay, let's kill some of this off here, so to speak. Moving over. Next item up for bid this evening. There's so many items. I don't think I'm going to get them all tonight. So at some point, I might have to self-edit. No thanks, MK says, written by Jan. Could be. Or, as we know Laura likes to do, the Chat GPT. Chat GPT might keep her as much of a friendly company. Keep her in friendly company. Yeah, what am I trying to say? Chat GPT might keep her in as much friendly company as David Gingras when they're working on her case together. No, that's not an allegation, but it is funny, at least to me. I'm not sure who vies for her affections more, David or the computer. No, he's totally not dating Laura. Everybody. That's the disclaimer. He's not dating. There's no romance, although I still agree with Ian Runkle. I can't make it work without there being some sort of romance. I'm with Runkle on that one. It's just yeah. I mean, how many more times can we dissect the relationships? Okie dokie, let's see. So this also from Clayton's Justice. They've been busy. Yeah, so is David. So is So the douche canoe, he's been busy posting blogs. I'm not talking about those tonight. We've got too much real paperwork to read. The Wank Fest at the Gingras Law Office blog. Just too much. Too much. So we've got this one. The amended notice of hearing on stipulated motion to dismiss with prejudice filed and docketed for 2026. Gosh, I'm so behind. And sorry, I can't embiggen because it's the Twitters. And I didn't see a Volo link for it. Is there? No, there's not. So this one hasn't been uploaded just yet to the Volo. All right. Amended notice of hearing on stipulated motion to dismiss prejudice. See, is this the same thing? Oh, am I getting them mixed up? Oh, good heavens. Good heavens me. No, hopefully I got the right one. Yikes. Notice is hereby given that a hearing on stipulated motion to dismiss with prejudice filed. Is this about the bankruptcy? Oh, I think I've already done this one. This is the bankruptcy. The stipulated motion to dismiss. Okay, so there's a hearing, folks. Mark your calendars. The hearing will be held on the 14th day of May. Now is the month of May. The merry lads are playing. Fa la 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 fa la la. Yeah. If any of you were in choir in like high school, you might remember that little ditty. 14th day of May, 2026 at 2:15 p.m. The hearing will be held in person at 230 North 1st Avenue, Phoenix, Arizona, in courtroom 701. So it sounds like this is a public hearing to me. I wonder if anybody will be in attendance for that hearing just to hear the results. I'm busy, sorry. I got to save some shekels for the criminal stuff because that's the main event. I don't want to waste my shekels on the sideshow or the freak show, as it may be. A copy of the motion is on file and available for review with the clerk. United Bankruptcy. Really? Okay. So there's a motion. Oh, we read the motion. Never mind. Any response to the objection must be in writing and filed on or before May 7, 26 with the clerk, U.S. Bankruptcy Court, mailed or hand-delivered to the same address, Phoenix, Arizona, with a copy served on the U.S. trustee at their address. I don't care about their addresses. And let's see, it's Eileen Leshinsky, U.S. trustee, also signed Jennifer Jaimo, trial attorney. Okay, so there's a hearing. Hearing May 14, everybody, for the bankruptcy. Hearing May 14. See, no thanks in cases. Chat HCG. Oh, golly. Oh. Okay, I'll give you that one. E. Broccoli says, I don't imagine saying my trauma was a story. Yeah. Well, for Laura, the stories are her trauma, maybe? Yeah, I don't know. I'm going to back up slightly. Just a little bit. Brett Girl 2015 says, regarding Hey Rob, I cannot wrap my head around how the law firm he used came up with those billable hours. Yeah, neither can I. That is insane. The attorney was clearly not a litigator. He wasn't even prepared. I agree. And I was so embarrassed when I covered it. I was practically speechless. It's if you haven't already heard Ricada and Megan talking about it, highly recommended. It'll get you all ruffled up all over again. Have your tranquilizers ready after listening to them go over the whole thing all over again. It was just absolutely ridiculous how bad it was. And I don't know how much longer I can say it. Let's see. Cracked Pepper says, Laura was searching for ways to disparage. Yeah, that's kind of her MO, her modus operandi. PCB Amy, if they leave it up, it's actually discrediting other TEDx speakers that were truthful. Here. Knowing they don't care if one of their speakers breaks their own guidelines says a lot. Yeah. And as Jennifer C. noticed, hey, looky, Laura's still the CEO of Quartet, especially on that one. Can't take that one down. Well, maybe they will eventually. Oh, my gosh. Let's see. Next item up for bid. Change tab. Cha-ching. Next thing from also at Clayton's Justice. Docket update and court documents for the Chapter 7 bankruptcy. Notice of hearing stipulated motion to dismiss. There's the docket entry. We just read the little blurb, the actual legal writing up of it. We don't need to look at that one. Next. Cha-ching. I just need to do my own sound effects, don't I? The State Bar of Arizona will be deposing David Gingras today. That was Thursday. today as part of the ongoing discovery in their case against him. This is not available to the public, damn it. But Godspeed, Jim Lee. Why is that? Maybe it will. Maybe it will be. Who knows? Someone likes to leak something on there. They like leaking things on their law office blogs. I'm just saying. They also say, no doubt we will get an unhinged blog post later today about it. Everyone else is at fault and Gingras is not. I saw his video. I skimmed through his ramblings on. He kind of patted himself on the back how well it went. So, of course, what else would it be? Unless they were telling him to hand over his bar card right there, there wasn't going to be an unhinged blog. Although it would have been entertaining. Okay, let's see. Is there anything here? The State Bar of Arizona by undersigned bar counsel, if I can get my multifocal eyes to adjust properly, hereby notifies the presiding disciplinary judge of the Supreme Court of Arizona that it intends, based on the present stage of the proceeding, to prosecute all the allegations remaining in the complaint. The allegations regarding respondents' comments about Judge Mata were addressed by the PDJ in the order in regards motion for partial judgment on the pleadings, which we read previously. Discovery is ongoing. The State Bar will depose respondent Thursday, April 23, 2026. That was this last Thursday. Yeah, he doesn't say much other than, he talked about cufflinks and French cufflinks too on his blog, so I noticed. Who cares? I don't care about his cufflinks. I just want to know, is the douche canoe going to get barred? Is he going to get slapped on the pee-pee? What's going to happen there? That's all we're interested in, really. The niceties, after all of the nasty stuff he fired in Jim Lee's direction, trying to make it a personal issue, I don't care. Oh, he's actually a nice guy and we had a good game. Whatever. Maybe we're just trying to say that to kiss ass because everyone's watching. I don't know. The man doesn't make sense to me sometimes. He really doesn't. He's erratic. He's unpredictable and erratic. I don't know what to say of it. It's dangerous. It's dangerous. All right, let's see what do we have here. Court documents for the State Bar of Arizona versus David Scott Gingras. Order motion to exceed page limits and PDJ inclination for procedural schedule for motion to dismiss / motion for summary judgment filed 4/23/26. The PDJ granted Gingras' request to exceed the page limits. Oh, God help us. Well, so that explains the 144 pages on Mark Randazza letterhead stuff. That explains that. Yikes. But warned that similar requests will not be approved in the future. The PDJ did not rule on the motion to strike and it is instead restructuring the process to deal first with whether Gingras has a valid prima facie case, valid prima facie motion to dismiss before deciding anything else. Hey, that's fascinating. Again, I can't embiggen this, sorry. Until we get some Twitter, Viagra, or whatever the hell we need to make this bigger. I don't know. Let's see. So this is the order motion to exceed page limits, PDJ inclination for procedural schedule for motion to dismiss, motion for summary judgment. April 23, 26. Boy, it was a busy Thursday. Deb Peterson. Hi, Deb. Deb says, yikes, he doesn't need an excuse to be more verbose. No, and when he's using Randazza letterhead, I think it's even worse. See, I can't imagine who types those things up. 144 pages. That's a dissertation. My God. So let's see. The presiding disciplinary judge has reviewed the respondent's motion for leave to exceed page limits filed April 14 of 26 in regard to his motion to dismiss and alternatively motion for summary judgment. The State Bar's response to respondent's motion. Oh, here we go again. The response to the respondent's responding of the responding's responses. Yikes. Motion for leave to exceed page limits filed April 20. Mr. Gingras' reply in support of motion to leave filed April 22, State Bar's motion to strike respondent's motion and dismiss, and alternatively motion for summary judgment. Good God. The PDJ understands the State Bar's concern that Mr. Gingras' motion to dismiss and alternatively motion for summary judgment exceeds the page limitation by over 2.5 times that authorized Rule 7.1, Arizona Rules of Procedure. response to motion to exceed page limits. The state bar raises concerns in its motion to strike with regard to the difference in the timing for a response for general motion made pursuant to Rule 7.1 and such regarding motion for summary judgment under Rule 56 Arizona Civil Rules Procedure and unique processing of a motion to dismiss pursuant to Arizona revised statutes. I feel like I need to be silly in some of this for some reason. It is ordered granting the respondent's motion for leave to exceed page limits. However, the respondent should not expect that future requests in parenthetical requests for the snake chorus for such will be granted. The PDJ notes that respondent's response time for the state bar's motion to strike has not expired, nor any state bar reply. Therefore, the PDJ will only rule on the motion to exceed and simply indicate. Okay. Yikes. PDJ will only rule on the motion to exceed and simply indicate or indication. Inclination? That's inclination. Okay, golly. I can't read. I really can't. See, this is where I need help. I need new eyes. Indicator inclination regarding the motion to strike, withholding final ruling on that motion until briefing is complete. The PDJ's inclination is as follows. Is an inclination like a ruling? What does that mean? While separate filings on respondent's motion to dismiss and the alternative summary judgment motion would have resolved the potential confusion raised in the state bar's motion to strike, the PDJ is inclined to proceed with issuing a procedural schedule regarding its review of the respondent's combined pleading, which will provide suspension of response by the state bar for all portions of the respondent's motion to dismiss and alternatively motion for summary judgment filed April 14 until the PDJ issues ruling as to whether the respondent has established a prima facie proof on the motion to dismiss. If the PDJ finds prima facie proof, the order will address the state bar to file a response per ARS, etc., and will hold the motion for summary judgment in abeyance until resolution of the motion to dismiss. If the PDJ denies the motion to dismiss, the order will provide a time frame for the state bar's response to the motion for summary judgment. Wow. So we've got some procedural things to clear up before things go further. All right, and that was April 23rd, 2026. James Lee, Craig, Mark Randazza and David Gingras. Okay, next thing. Now it gets thick, people. And as you can see, there's still no Jeep Daddy appearing. I don't know what the hell he is. Maybe he's comatose. He had too much to eat and drink, and now he's just not going to bother. That would be just like him. Or he's or could he? Maybe he's getting mango custard for dessert. I don't know. I have no idea what's going on. Oh, let's see. I need to close some windows. It's getting too cluttered in here. All right, the next item up for bid. Oh, are you ready for this? You know what? Let me come back to this. Let's do the shorter things first, for heaven's sake. Oh, let's back up slightly. Like I said, this isn't going to be chronological because it's just messy, and I didn't bother to put them together that way. And it's okay, Deb Peterson. Yeah, this is hard to follow. It's hard for all of us to follow. We'll back up slightly. We'll back up to more bar stuff. So let's see. The notice: the state bar's intent to prosecute remaining allegations of misconduct. This is important. The State Bar of Arizona, by undersigned Bar Counsel, hereby notifies the PDJ of the Supreme Court of Arizona that it intends, based upon present stage of the proceeding, to prosecute the allegations remaining in the complaint. We like that. Oh, wait, I already read this. Gosh, it's the same darn thing. Okay, I've got some stuff on Volo. All right, fine. What's this? Let's share this one instead. State Bar's response, motion to expedite. Oh, this could be entertaining. Let's see what the state says about David. State Bar's response to a motion for leave to exceed page limits. Oh boy, it's only a few pages. Before the presiding disciplinary judge, the State Bar of Arizona, by the undersigned Bar Counsel, in fact, moves the presiding disciplinary judge to deny respondent's request that he be allowed to file a motion to dismiss, and alternatively, motion for summary judgment. Okay, so this is backing up slightly for those of us who didn't follow what came earlier. That exceeds the page limitation for motions by over 2.5 times that authorized by rule. Respondent's motion to dismiss and the affidavit and exhibits thereto is lengthy in part because it addresses some matters that are relevant to determining whether dismissal is appropriate. Of course it's got stuff that's irrelevant. It's a douche canoe filing. Buttons.
The fucking douche canoe.
That's what I get for being on the wrong page on that set of buttons. Respondent's motion to dismiss. Okay, let's read the footnote. All references to the two rules are the Arizona Rules of Civil Procedure, which are incorporated into Supreme Court's lawyer discipline rules, unless otherwise noted. Okay, I like footnotes. Of course he wants to exceed page limits. Of course he does. No thanks. Of course he does. He wants all the page limits thrown away. I think because he's helping write some of them. That's my feeling about things. It may be on Randazza paper, or so to speak, but I think there's a lot of douche canoe condensed into it. He probably said, "Here, Mark, this is what I worked on. Could you put it on your letterhead?" And there may have been some little massagings here and there, but there's a lot of stuff that seems to be David to me. But that's just my opinion. For example, respondent raises claims under ARS which are moot based on the PDJ's April 14 order granting in part the State Bar's motion for partial judgment on the pleadings. The State Bar has filed contemporaneously herewith a motion to strike respondent's motion to dismiss on that and other grounds. Respondent's motion to dismiss included nearly 6 pages addressing the allegation that he made unprofessional, disparaging remarks about Judge Mata and 3 pages of additional, in quotes, issues. He also submitted 28 pages of disclosure statements and exhibits to his affidavit in support of his motion to dismiss, which are not, themselves, proof of the factual assertions in his motion. Furthermore, the motion to dismiss included assertions of fact that remain disputed. And there's case law there, blah, 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 blah. Requiring respondent to file separate motions under Rules 7.1 and 56 would likely limit, to some extent, respondents' need to exceed the 17-page limit for motions. That's it, 17 pages. Wow. How it ballooned exponentially. Conclusion. Based on the foregoing, the State Bar moves the PDJ to A. Deny respondent's motion to exceed the page limit for motions, at least to an extent his motion to dismiss, and alternatively, motion for summary judgment exceeded the 17-page limit by 29 pages. B. Enter an order granting respondent's request to exceed page limit by an amount deemed reasonable and appropriate by the PDJ. And C. Enter an order limiting the number of pages for respondent's affidavit and exhibits, which would prohibit the inclusion of irrelevant text and exhibits. Oh, sorry, Dr. Lee. He's already filed something huge. And it's huge. And we'll take a look at it right now. Oh, holy yikes. Okay, close that tab. Oh my God. I don't know if I'm going to make it, folks. Not by myself. Where is that guy? I think I should text him. I should see. Are you having dessert too? That's what I'm going to text him. Hold please while I text a snarky thing to Jeep Daddy. Okay, the deed is done. All right, so let's see. The affidavit of David S. Gingras in support of respondent's motion to dismiss summary judgment. Oh my God. If you haven't had your potty break, that was the time to take it. That was the time. Have your snacks. This thing's 144 páginas. 144 pages. We may skip. Because I don't think I have it in me tonight. No, I don't think I do. And as you can see, because we can, in fact, and big in this one, it has Randazza Legal Group on the side. I don't know why we've got side margins, but there it is. So let's see. Affidavit of David S. Gingras in support of respondent's motion to dismiss and summary judgment. This might be entertaining. There may be some juicy things in here. I don't know. I haven't looked at it yet. Hi, David Gingras, citizen of the U.S., 18 years older, licensed attorney, boo. Oh dear. Oh my gosh. Oh, hang on. There's a response from Jeep Daddy. Hold, please. Okay, he says he's on his way home. I might be done by the time he gets home. In which case, he can be punished by you, chat. I will allow chat punishment for Jeep Daddy for not holding his schedule firm.
I think they should be punished. Punish! 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 Punish!
Attorney licensed to practice in Arizona, California. Found affidavit Owens v. Eckerd. Affidavit. Every state. At the time I submitted my affidavit in Owens v. Eckerd in July of 24. Every statement in it was true and correct to the best of my knowledge. Boo! Boo hiss. Do I have boo hiss? Boo hiss, tomato, tomato. I've learned that from Bacon Bears lately. Boo hiss, tomato, tomato. I like it. It's funny. Let's see. Reviewed my July 24 affidavit. Confirm once again that everything is true. Only the following there's updates, huh? In several places, I described a number of followers of certain social media accounts and the number of posts made by some of those accounts and by me regarding the Owens v. Eckerd case. All of the numbers in my affidavit were accurate at the time. In the nearly 2 years that have passed since then, the number of posts, social media follows have increased significantly. Oh no! Oh no, the number of followers watching Laura Owens commit fraud, in our opinion, has increased significantly. Oh no. I wish I had Snake Chorus. Oh, I need Snake Chorus so badly. What else does he say? In paragraph 67 of the affidavit, I provided a link to a YouTube page where a video could be viewed showing several people making allegations concerning Judge Mata. They weren't allegations. I'm not... Oh, God. Why am I doing this to myself already? We're an hour and 17 in. That link is no longer working, but the same content is available on my website here. Or on YouTube here. You know what? I'm going to be bold. Where does this take us?
So I went and saw Judge Mata's dad in the parking lot afterwards.
Oh.
And I asked him, like, well, what did you think? He was like,
Oh.
I got to show you something.
This takes us to David's sock account page on YouTube, also known as David Smith AZ. As you can see, you know what? Can I make that bigger? Can I embiggen that more? This is David's other YouTube account. Right there. And I am watching it, by the way. Yes, I am. I'm also watching someone on their new Rumble page, just because, we like to be attentive to things. If they can watch us, I can watch them back. Turnabout's fair play, in my opinion. Okay, so this is that little tablet recorded thing that I think Laura made or whomever. Doesn't matter. It's icky. We'll go back to the document. Let's see. The rest of his videos that are public on the David Smith AZ, aka David S. Gingras. The S does not stand for Smith. Are his other exploits, shall we say, professionally with what's his name of the dirty, and I think was Colin Farrell on that one. We might talk about his appearance with Colin Farrell. I found that the other day. It was being talked about on the Justice for Clayton Reddit, and yeah. Oh, as Big Bad Marcus says, David Smith AZ equals AZ Gardner equals Justice for Laura Volunteer. Congratulations, sir. You have cracked the case. Oh, no, that's the wrong button. Or, in the words of another comedian,
Gotcha, bitch.
Yep, gotcha, bitch. Yeah, see, I pay attention to these things. This is why when there's silly things being said in my comment section that are most certainly Laura and or David, and I'm quite sure that Laura also participated in that same string, because I know some of the other aliases. There may or may not be a database of her other aliases she's been known to use online. There may or may not be. I can neither confirm nor deny. There may have been discussion. Okay, back to the paperwork. There's 144 pages, people. This is insane. Incorporate all of the statements in my July reference. Submit a declaration, blah, blah, blah. Just run the pleadings, conform, blah, 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 blah. Skipping. Everything in my March 1826 declaration was true and correct to the best of my knowledge at the time. I executed the declaration. The facts remain accurate today. Yeah, okay. He's still a douche canoe, in my opinion. All right, let's see. Facts relevant to Claim 1. Violation of a court order. Oh, here we go. Do you have your popcorn? Do you have your dessert? Whatever it is you're enjoying at the end of this Sunday evening. Now's the time. Now's the time to enjoy your treats. Facts relevant to Claim 1. Violation of court order. I already said that. Ugh, yikes. 10. I won't read all the numbers. I'm aware the complaint in this case accuses me of violating a court order by publishing information the court had ordered to be sealed or otherwise protected. The court ordered that you don't disclose it to anyone other than the parties and the court. That claim is 100% false. As a matter of fact, I did not violate any order at any time. Liar. Just because you don't pay attention to what happened earlier in the file does not make you culpable when you get it wrong. Mr. Douche Canoe.
The fucking douche canoe.
It's outrageous. Immediately after Miss Owens retained me on March 25th of 2024, one of the first things I did was to ask her whether the court had issued a protective order. Why do you need to ask her? Look at the damn file. You can look at the pleadings. You can look at the judgments. You can look at the record. It's not her responsibility in total. She may not have she may have no understanding whatsoever whether or not that was an order or a suggestion or just friendly advice from the judge, from Judge Mata. It is your job, sir, to know what the court is telling the attorneys and the parties, especially your party. Her response, that being Laura Owens, was, "No, I asked for a protective order multiple times, but the judge denied every one of those requests." So this is negligence, really. It is litigator negligence. Is there such a thing? Am I making up words? My goodness. Let's see. E. Broccoli says, "I want to see the database. Eyes. Maybe one day. A number of us, I think, will get together. We may work on that. We will put our heads together. That's all I'll say at the present time. Otherwise, I'll need attorneys myself. I've got enough already to deal with. I don't need more. I don't need my work attorneys, and I don't need the ones I've got on standby for anything I may have in regards to this." Okay, let's see. Her response was no. All right, next. Ms. Owens told me the court denied multiple requests for a protective order. I reviewed the docket and confirmed her statements were accurate. I found Ms. Owens made 3 separate requests for confidentiality sealing orders, all of which were denied in full because she wanted to keep it a secret. She didn't want her dirty fraud getting out in the public where people could discover it. As I discussed in more detail in my March 1826 declaration filed in the case, I also noted that in his pleadings, Mr. Woodnick, oh golly,
Ew.
no, that's not the one I want. Damn it, Mr. Woodnick. I had a crisis of deciding which button to push. Mr. Woodnick angrily opposed Miss Owens' second request for a protective order, arguing any order prohibiting the parties from making public statements about the case or sharing information obtained during the case would be unconstitutional. Yeah, that would be true. It's a public case. In my March 18 declaration, I included various quotes from Woodnick's brief opposing Owens' request for confidentiality. These quotes from Woodnick Whitnick said he didn't want confidentiality, so therefore I shared everything because he didn't want it. I don't care what the judge said. That's kind of what this reads like. See, those quotes from Mr. Whitnick's argument are worth repeating. It sounds like a snarky, spoiled teenage brat. Petitioner's requested relief under Rule 53 constitutes an impermissible prior restraint of protected speech. Oh, sorry, this is Whitnick talking, not David. Beyond that, it also represents tremendous overreach in the use of Rule 53. We need to read it more dignified if it's Whitnick. That's how this goes. Overreach in the use of Rule 53 to diminish respondents' rights as a litigant. Apparently, petitioner feels she is entitled to what is essentially a backdoor motion to seal after this court had already denied her attempt. The court must begin with the presumption that prior restraint on protected speech is dubious and subject to the highest scrutiny. Petitioner does not address or even attempt to explain why prohibiting respondent from speaking about the issues she brought in this action would withstand constitutional scrutiny. Petitioner's demand would trigger a woefully unnecessary and inappropriate procedure overtly designed to thwart disclosure. The fact that discovery may annoy or embarrass petitioner does not mean that sealing and confidentiality are appropriate remedies. Not only is respondent entitled to the information and discovery necessary to defend against her claims, but he also has a fundamental constitutional right to discuss the nature of those claims, just like any other litigant. Petitioner is requesting an order that would prohibit respondent from defending his character in public view, despite the fact that she made his character a matter of public interest, and that she self-identifies as a public figure. The toothpaste cannot be put back in the tube. It is premature to designate as confidential documents, recordings, or records that do not exist and have not yet been produced. To the extent a response to this assertion is warranted, there is nothing to be designated confidential. Again, Mr. Whitnick's final statement to the court was clear and unequivocal. There is nothing to be designated confidential. I've been practicing law for around 25 years. During that time, I've personally litigated hundreds of First Amendment cases in both the state and federal court. Based on that experience, I know courts typically can issue lawful orders preventing parties from disclosing certain types of information obtained in discovery. For example, in my experience, it is common for courts to issue protective orders limiting the disclosure of certain types of information, such as financial records, proprietary trade secret information, and personal medical records of the opposing party. Although courts routinely order a party not to disclose private confidential information they received from the opposing party, in 25 years of experience, I have never seen a judge order a party not to publicly disclose their own records or similar information. I'm also extremely familiar with the circumstances this court can allow and order information to be filed under seal. Based on that experience, I know sealing orders are extremely technical and complicated, and they involve numerous procedural requirements to ensure absolute clarity for the lawyers and litigants. Here, attached here too, as Exhibit A, is a copy of my third supplemental disclosure statement submitted in this matter. As I explained in this statement, in my practice as a civil litigator, I have often dealt with both protective orders and sealing orders, so I'm very familiar with standards for both. That's right, I'm very familiar with both. Based on my knowledge, experience, and training as a civil litigator with decades of experience, I know exactly what a protective order looks like and what it smells like and what it tastes like. And I know what a sealing order looks like. I just had to add a couple more. I couldn't help it. Sorry. In Owens v. Eckert, the trial court never at any time issued either protective order or sealing order. I'm aware that on February 21, 2024, Judge Mata issued a lengthy minute entry ruling which resolved multiple issues. In that document, Judge Mata issued several orders, including an order denying Ms. Owens' counsel's request for reconsideration regarding confidentiality. In that same ruling, Judge Mata included an observational comment. It wasn't an observational comment. What? Oh my God. An observational comment stating, let the record further reflect. Excuse me. Wrong voice. Let the record further reflect that no party shall disclose outside of themselves any medical or other documentation, exhibits, medical records, etc., disclosed between the parties. My understanding of that language, based on discussions with Miss Owens and my review of the file as a whole in this, although Judge Mata denied Miss Owens multiple requests for confidentiality, she nevertheless did not want Mr. Eckerd's counsel, Greg Woodnick, abusing those rulings by gratuitously sharing Miss Owens' medical records on social media. That's not what this was about at all. Oh, he's so infuriating. Deb Peterson says he always feels the need to toot his own horn and tell us how great he is. The truly great ones don't have to say a word. Hear, hear, Deb Peterson. Hear, hear. That conclusion was based on the fact that Mr. Eckerd never disclosed any medical records at all. So the comment about the parties not disclosing outside of themselves any medical or other documentation, exhibits, medical records, etc., disclosed between the parties, could have only been meant as a restriction on Mr. Woodnick's ability to share information he obtained from Miss Owens. The lying bastard. That's not what it said. It's not what she said, and that's not what she meant, in my opinion. Alternatively, let the record reflect may have documented some sort of agreement between Miss Owens' prior counsel and Mr. Woodnick. I do not know if that was the case because Mr. Woodnick refused to discuss the matter with me, and Miss Owens' prior counsel, Cora Keith, was also not helpful after I was retained. Despite the language stating, no party shall disclose outside of themselves or any medical other documentation. The document, which never said it is ordered, said nothing about sealing records or requiring pleadings to be filed under seal. I am aware there's a specific rule that deals with this exact issue, Family Law Rule in 17, sealing, redacting, unsealing court records. Rule 17 allows material to be filed under seal, but the rule contains multiple mandatory prerequisites. First, the court must make written findings of fact and conclusions that the specific sealing or redaction is justified. Second, the court must find there exists an overriding interest that overcomes the right of public access to the record. You know, it's very helpful to have Laura's HCG numbers so we could find out that she was in fact committing fraud. February 21, 24, minute entry contained none of the findings required by Family Law Rule 17. For that reason, I did not believe that the court required or even allowed any information to be filed under seal. In addition, shortly after I was retrained, I learned that after the February 21 minute entry ruling was issued, that Mr. Woodnick, that evil Mr. Woodnick, filed unsealed pleadings to which he attached medical or other documentation exchanged between the parties. Specifically, a few weeks after February 21 ruling was issued, on March 11, Mr. Woodnick filed an unsealed pleading containing medical or other documentation exchanged between parties available at the appeals, blah, blah, blah. I don't care. Paragraph 49 of the amended complaint claims that on April 4, 24, Mr. Woodnick sent me an email in which he stated, I am also not... Oh, excuse me. Wrong voice again. Damn it. I need a director. I'm also not certain why you are publishing court documents and your client's personal medical records contrary to court order. That allegation is true. Mr. Woodnick did say that in an email. However, the complaint fails to explain what happened next immediately after I received Mr. Woodnick's email on April 4, 2024. I sent him a lengthy response. Mr. Woodnick, a very lengthy and girthy response. Mr. Woodnick's email was sent at 12:56 p.m. I replied to him at 1:30 p.m. Literally 34 minutes later, this email exchange is attached as Exhibit B. B for beta male. In my email, I responded to Mr. Woodnick's comment about publishing court documents in your client's personal medical records contrary to court order as follows. And I quote, first, I'm aware of no court order that would stop Laura from publishing her own medical records. Yes, I'm aware there's a minute entry order dated 2/21/24 that says, among other things, no party shall disclose outside of themselves, odd wording, any medical or other documentation disclosed between the parties. I was obviously not present when that order was entered, so I may not have the full context, but my reading of this is if Laura discloses medical records to you, you can't share them publicly. And if Clayton shares records with us, we can't share them publicly. That's typical. And it is how I read the court's order. If my reading is correct, it does not prohibit Laura from posting her own medical records, which she did solely to rebut the false claims from your side that no such records existed, which were proven to be fraudulent anyhow. So what difference does it matter? There is nothing nefarious or improper about this. If you interpret the order to mean that Laura somehow enjoined from publishing her own records for the purpose of responding to the false statements other people are making, including Dave Neal, who Clayton is clearly working directly with. Ooh. You need to let me know immediately so I can take the issue up with the judge. There is clear case law on that issue. A court would never issue such an order, which is why I give the minute entry order a narrower reading. Any broader reading would make the order unconstitutional. In fact, the order would be void ab initio. Sorry, I can't quite read it right. Meaning, it could be simply ignored. Oops. I need an oops button. In fact, let's see. I know this because I've litigated the identical issue in other cases. In Phoenix newspapers, Superior Court. I'm very famous. I'm so famous I was on Dr. Phil. Holding order prohibiting disclosure of details court order hearing violated our constitution was void. Superior Court had no authority or close to discussing printing proceedings held no court. Okay. Laura's medical records were filed in a pleading submitted to the court, and which is a public record. There's no protective order against this, nor would there be any basis for one, so anyone is free to share that information with the public, which is all I did. Emphasis in original. Mr. Woodnick never responded to my statement. If you interpret the order... If you interpreted the order to mean that Laura is somehow enjoined from publishing her own records, you need to let me know immediately so I can take the issue up with the judge. Oh, we already said that. He's saying things over again. I interpreted the lack of any response from Mr. Woodnick as an admission from him that my view was correct, i.e. that the court had not issued any order that limited Laura's ability to share her own medical records for the purpose of responding to false statements being published by Mr. Eckert and Mr. Woodnick. Because Mr. Woodnick appeared to agree with my interpretation of the order, I saw no reason to seek further clarification from the court. If Mr. Woodnick believed that I had, in fact, violated court order, he could and should have raised that issue directly with Judge Mata. He never did so. Facts. Pardon. Facts relevant to Claim 2. 911 call R.E. Michael Maricini. I understand the bar accuses me of engaging in misconduct involving witness intimidation. It's in air quotes. Related to a person named Michael Maricini. That allegation is patently false, even though I did actually call 911, what was it? 911? 119? Whatever it is. It is also based on an intentional and misleading omission of additional details regarding the issue. After I was retained by Miss Owens on March 25th, I attempted to interview all the witnesses disclosed by Mr. Woodnick. One such witness was Michael Maricini, who I understood was an ex-boyfriendio of Miss Owens from San Francisco. Although Family Law Rule 49, that's not 69, that's 49, required Mr. Woodnick to disclose the names and addresses of all witnesses he intended to call. The only contact information provided by Mr. Woodnick for Mr. Maricini was a lawyer in California named Brandy Sue Pollock. In case you didn't know, this is going to be more Owens v. Eckert and Owens v. everybody stuff, history. Not really relevant to his disciplinary proceeding, but he's going to relitigate everything until he's blue in the face. In mid-April, I called Miss Pollock to discuss Mr. Maricino's testimony. Maricini. We'll be fair. During the call, she told me that she never heard of Owens v. Eckert and she did not believe Mr. Maricini intended to testify in the case. I asked her to verify this and please send me email letting me know either way. April 19th, I received an email from Ms. Pollock stated, Mr. Gingras, my client will not be testifying. I responded and thanked her for letting me know. A few days later, Mr. Woodnick disclosed new evidence, text messages between Ms. Owens and Mr. Maricini, which made it appear Mr. Maricini was, in fact, planning to testify at trial, contrary to what Ms. Pollock had just told me days earlier. May 6th, 24, I called Ms. Pollock to request clarification regarding Mr. Cheney's position. During that call, I told Ms. Pollock that if Mr. Maricini wanted to testify, that was fine with me. I also explained that Rule 49 of the Rules of Family Law and blah, blah, blah required Mr. Woodnick to disclose a description of Mr. Maricini's testimony, which Mr. Woodnick failed to do. I told Miss Pollock that if Mr. Maricini was planning to testify, I was entitled to speak to him beforehand, which could be done in either an informal interview or a deposition. In response to those comments, Miss Pollock became extremely hostile and angry. Yeah, I wonder why. I wonder what else was said that might have made her a little bit hostile towards Mr. Douche Canoe. I wonder if perhaps he might have been a little bit coercive. I wonder. We know how misogynistic he can be in his interactions with ladies. So I can't imagine it was the most congenial of conversations. And Rachel Juarez, also in her time on Reality Steve when he was reading his Laura Owens emails, there was some talk about the nasty things that David said about Rachel. So we know David can be nasty, particularly against women in his own field. I'm told that it's pretty nasty from Mr. Douche Canoe in regards to the vivacious and incredibly talented Rachel Juarez. I don't know how you could be nasty to that woman, other than he's got issues. She specifically told me, "We are not willing to cooperate with you." I responded and told her that cooperation was not optional if Mr. Maricini wanted to testify, and I told her I had a right to depose all witnesses, including Mr. Maricini, and that he was legally obligated to cooperate if he wanted to testify. Miss Pollock's response to that was, "Well, maybe Mr. Maricini won't testify, but he will show up just as a spectator at trial." After Miss Pollock said this, I reminded her that Miss Owens had a valid domestic violence restraining order against Mr. Maricini, Exhibit C, issued by San Francisco County Superior Court, and I knew Miss Pollock was aware of this because she represented him in that case for several years. I further reminded Miss Pollock that if Mr. Maricini engaged in interstate travel with the intent to violate the order, that would constitute a serious federal crime. God. In making those remarks, my email to Miss Pollock was exceedingly clear. 1. If Mr. Maricini intends to testify at trial, then I have an absolute right to know this, and I have a right to interview him. That interview can be done on a phone call, blah, blah, blah. Let's skip a little bit. Just skip a little bit more. On the phone, you suggested Mr. Maricini may just show up at trial rather than participating as a subpoenaed witness. He would simply choose to be there. If that is his plan, I need to be clear about our position. If Mr. Maricini shows up either as a spectator or as a non-subpoenaed witness, Laura will ask the Phoenix police. See, this was premeditated. This was premeditated to do this. Premeditated to call the cops on him just for the sake of calling the cops. They should have got him for a false police report, in my opinion. They should have busted both of their asses. If it was Laura's idea, they should have busted hers. And if it was his idea, they should have busted his. False police reports are a thing. See, no thanks. MK says, I'd have ruled on this, and yet here we go again. Yeah, it's true. He can't help himself. He is so butthurt he lost, as he tends to do. As Senior Bar Counsel Jim Leo said, David just wants to relitigate the whole thing all over again. And that's mostly what this is. But it is kind of consolidated and amusing in one place. And, the dingus lisp kind of works, I think. I mean, usually I read with a little southern twang when it's him, but it kind of works. Yeah. Let's see. He'll be immediately arrested for violating the restraining order issued against him. In short, I agree Mr. Maricini can't testify at trial without fear of arrest, provided he complies with the rules of procedure. That means, among other things, I have the right to interview him and take his deposition if necessary. Sounds extortion to me. Wait, is that black? No. Yeah, it seems kind of coercive and extortive in my way of thinking. If Mr. Maricini does not want to comply with procedural rules, that's 100% okay. I am more than happy if he wants to stay home, assuming he hasn't been lawfully summoned. But if he comes within 100 yards of Laura without being compelled to appear by a valid subpoena, then he will risk arrest and prosecution for violating the restraining order I, Dingus, have thusly declared. Note, Rule ER34 of Arizona Rules of Professional Conduct provides the lawyer shall not request a person other than the client to refrain from voluntarily giving relevant information to another party. Based on this rule, I assume Mr. Woodnick has not instructed you or Mr. Martini to refrain from speaking to me. If that has occurred, it would be a per se violation of the ethical rules. Also, just to be clear, I am not under any circumstances suggesting Mr. Martini cannot participate in the trial if he has relevant information. All I'm saying is that if he wants to testify, he needs to do so in a manner that complies with the rules in the law. This is mandatory to ensure basic fairness to all sides. Finally, please note that if it's a felony under Arizona law for any reason to unlawfully withhold testimony, to evade legal process, to appear and or fail to appear when legally summoned, for avoidance of any doubt, nothing in this email should be construed as an attempt to cause Mr. Martini not to appear, but we're going to call the police on him if he does appear and they don't like it and he doesn't give in to my demands. That's called witness intimidation. On the contrary, I'd very much like him to appear, provided he does so in a manner that complies with the rules, including the rule that requires prompt disclosure of substantive testimony and the rule which entitles me to appear in prior trial. My email to Ms. Pollock could not have been any clearer. I did not say anything that was intended to intimidate Mr. Martini. Bullshit. Where's my bullshit button? Damn it, where the hell is it? Nope, that's not it. Bullshit! There it is. God, all the buttons start to look the same after a while. My email to Ms. Pollock could not have been clear. I did not say anything that's intended to Mr. Martini, nor did I attempt to prevent him from testifying. I only called the police on him because, well, I say so. And then I tell people on like Reality Steve's thing with Rachel Juarez, I claimed that Laura was having a freak out and she made me do it. Yes, she did. She made me do it. She was threatening me with all kinds of things. I don't know. I'm making that up. I'm being silly. On the contrary, I understood that if Mr. Martini had relevant testimony, Mr. Woodnick was entitled to obtain testimony from him and present it to the court. I had no objection whatsoever to that happening. At the same time, while Mr. Woodnick had the right to obtain relevant testimony, he had a corresponding duty to disclose a summary of that testimony to me before trial, an obligation he violated. Because Woodnick violated the disclosure rules, I was lawfully entitled to ask the court to exclude Mr. Martini as a witness based on non-disclosure pursuant to FLR, which I later did. At no time did I ever suggest that Ms. Owens' DVRO against Mr. Martini could serve as an independent legal basis for excluding Mr. Martini's testimony. I did not think that was true at the time, and I do not believe that today. Rather, my position was that Mr. Martini simply needed to comply with the DVRO while testifying. In other words, Mr. Martini could have appeared by phone or by Zoom, just like Laura Owens does all the time, even when she's told to get her skinny little ass in court, like in San Francisco. But, you know, she was dying. She was in the hospital. She was dying. She was bleeding from I don't know where, from everywhere, I guess. And she just couldn't do it. We had to have, you know, disability accommodations because, you know, she told the court she was going to have a medical emergency if she had to show up. And so she did. She had her medical emergency and decided not to show up. And then she went to a horse thing, you know, where they jump the horses back and forth. Boop, 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 boop. The court could have simply allowed Miss Owens to leave the room before Martini took the stand. None of those options were used because Judge Motter refused to allow me to be heard on the issue prior to the start of trial. Really, I'm lying about that too because I didn't want to waste the 5 minutes because she was going to deduct time for people going up and sitting down. And I just wanted to ramble on and have Laura Owens, spill her lies and perjure herself. I kind of knew she would. I added that too. On the morning of June 10, Miss Owens told me she saw Martini violate the DVRO by getting too close to her. She felt it infringe upon her blowjob bubble. It was whoop, whoop, whoop. The alarm bells were going off. Yes, they were. She told me she was absolutely terrified. He was in the parking lot of the courthouse. In case you didn't know, she told me she was absolutely terrified and that she didn't know if she could go through with it. Meaning the sitting in the courtroom with Martini. Miss Owens further told me that she felt she had to leave the court unless I did everything possible to have law enforcement keep Mr. Martini away from her, as the order specifically required. Reading so much, my butt's getting tired already. Based on Miss Owens' request and to prevent her from walking out, let her walk out. Then she's a failure to appear, and then things get really bad. Let her walk away. God. I'm sorry, Your Honor, but Miss Owens has decided she didn't want to show up today. Just like she doesn't show up to anything else any other matters she fraudulently files, allegedly. Oh my God. I contacted Superior Court Security, informed them of the violation of the order by Mr. Maricini. Security personnel told me they could not enforce the court orders, and they said my only option was to call Phoenix Police, which I did. When Phoenix PD arrived, I handed them the copy of the DVRO, which is the Relevant Provision of Violence Against Women Act, which required the California order be enforced in Arizona. I had that statute with me because I anticipated some confusion over the issue, and I really wanted to get him arrested because I wanted that for my girl Laura. She wanted it so badly, and just like the little princess she is, I wanted her to have it. So I wanted to help police understand legal requirements of VAWA. Over my 20 plus years as an attorney, I've handled many family court cases. I claim to be a free speech attorney. I handle many family court cases, including cases involving restraining orders, harassment, injunctions. Based on that experience, I know such orders are taken extremely seriously, and I've personally seen clients arrested and incarcerated for even minor unintentional violations of protective orders. For instance, I had this one case. Let me just tell you the story. I had a client who simply called his office to check messages. His ex-wife, who obtained a protective order against him, answered the phone because she worked for the same company. That client was later arrested and spent 6 months in jail for unintentionally violating a protective order, making a single phone call to his own workplace. He owned the company. Prior to arriving at court on June 10, 2024, I spent several hours doing legal research into the question of whether an Arizona subpoena could somehow excuse the violation of California DVRO. I found no legal authority, and if I looked very hard, I had no idea. I found no legal authority to support the position. Instead, beyond the plain language of VAWA itself, I also reviewed Rule 28 of Arizona stuff. When two parties have obtained conflicting protective orders, both orders must be given full force and effect. That rule is supported, in my view, that even Mr. Woodnick had served Mr. Maricini with a valid subpoena to appear, which I was not aware of on June 10. How could he not? He's not paying attention then. That's part of the record. That subpoena, to the extent, would not be sufficient to override the California. Instead, both the subpoena and the DVRO were required to be given full force and effect. How people get anything done in court with that sort of thing, I don't know, but I wanted it to be that way for my girl, Laura. She's a special princess. She really is, and she deserves everything. She deserves it all. She's earned it. Based on my research, I understood that Mr. Maricini could appear at trial because the subpoena constituted a legal process requiring him to appear, but at the same time, he was obligated to stay 100 yards away from my Miss Laura. In other words, I have no valid reason why Mr. Maricini could not comply with both orders, the DVRO and the subpoena. Mr. Maricini never testified at trial because Mr. Woodnick never called him as a witness. Facts relevant to Claim 3. Air quotes. Assholes. I'm aware, in paragraphs there, of the amended complaint accused me of sending a private email in which I referred to certain anonymous individuals as total fucking assholes and, quote, total fucking psychotic assholes. Those words are accurate. They can't be. They can't be. It can't be literal. Because no one is a walking sphincter. Although, I mean, there's plenty of people that certainly act like it. No one is. Okay, move on. Those words are accurate. I used them in a private email I sent to a website called Reddit. The purpose of that email was to notify Reddit that one of Mr. Eckert's supporters infringed upon my copyrighted material by taking videos I was posting on YouTube and creating derivative works that would fall under fair use. God damn it. Which she then posted on Reddit in violation of 17 U.S.C. 106. Fair use, you fat pig. Oh, God, now I'm getting snarky. No, I just have bacon on my mind. I have bacon bits. I want some bacon. No, I'm not soliciting bacon bears. No. She's spoken for, and I play for the wrong team. That the email mentioned as the fact that I'm a lawyer, and I briefly described Owens v. Eckerd to offer some context for the request I was making. However, the sole purpose of the email was to enforce my own legal rights under Copyright Act. I was not acting on behalf of my client. I was acting solely for myself. I want to say something there, but I won't. As such, I was not engaged in the practice of law, even though I identify myself as a lawyer. So really, I am engaged in the practice of law because I told him I'm a lawyer and I'm doing this little thing. As a general rule, I always try to be polite and professional in my dealings with others. However, under appropriate circumstances, I may use colorful language if I believe it is necessary. In this instance, the language I used was entirely necessary. Entirely necessary. Also, as a lawyer, I'm also aware that other attorneys sometimes use similar language for effect. That's a classic example. In the 70s, a lawyer sent a letter to the Cleveland Browns football team complaining that fans were throwing paper airplanes during games. The letter was widely considered to be absurd. That view was shared by general counsel for the Browns, and who responded with this short but extremely famous response. Oh my God. Oh, Danny's back. Nice job holding your own. Thanks, Danny. Big Bad Marcus says, not me getting all jealous of Echoes being heterosexual for bacon bears. Well, we all make mistakes, don't we? Danny's still here, but multitasking. Oh, good for you. I'm trying. I don't think we're gonna have a Jeep appearance tonight. I think he's already got his jammies on. He's probably passed out. Let's see, Cleveland Stadium Corp. Dear Mr. Cox, attaches a letter that we received in 1974. I feel that you should be aware that some asshole is signing your name to stupid letters. I like that. Oh my gosh. Moving along. Open Substack. Oh, and it's on a Substack even. Yikes. Gingras continues. My use of colorful epithets in my private email to Reddit constituted an exercise of my rights under the First Amendment. Speech for me, but not for thee. I do not believe attorneys are required to waive their First Amendment rights as a condition of joining the bar, except with respect to narrow areas, which has clearly been defined by the U.S. Supreme Court. Facts relevant to Claim 4. I'm aware in paragraphs 114 to 77 of the complaint, the bar accuses me of a variety of misconduct, which can generally be summarized in following one or more of these categories. Knowingly offering false testimony from Ms. Owens to court, negligently offering false statements from Ms. Owens by failing to diligently verify her story, failing to address false or inconsistent testimony offered by Ms. Owens. With respect to the claim that I knowingly offered false testimony from Ms. Owens, this is 100% categorically untrue, even though there's evidence of me being told that some of her evidence is false. Yeah. And the State Bar has no evidence of any kind to support it. I did not knowingly offer any false testimony at any time. That allegation is blatantly false and defamatory. And you know what Jack Fox says about LY words, folks? There's plenty of them here. You can get LY word bingo reading through this stuff. So if you are playing LY endings for words in bingo, you may have bingo already. Marcus says, I can take JD's place. Everyone chant, I'm information security 10 times. Ooh, that could work. That could work. Poof. Poof, what do you need? Poof, what do you need? Poof, what do you need? You could be like the genie in Aladdin. Danny says to Marcus, dealing with tech issues, including settings that want to track everything about me, I was actually thinking, what would Jeep Daddy do as I try to navigate it all? Very good, Danny. He would be so proud. Excellent. At some point we might just have Jeep Daddy tech time or something. I'll have to ponder that. We're too busy drowning in Laura Owens and Dingus the douche canoe. Oh, let's see. That allegation is blatantly false and defamatory. Uh-oh, I've been booped at. Someone's entering the studio. Ooh, he's in the dark. Ooh, I like it. Let's put him up. Is he driving?
Hi. Yes, I am.
No. Are you breaking? I can't have you while you're driving.
Actually, no. This is all a virtual background, and no, that's not at all breaking any laws or rules of the state.
I know nothing.
Yeah.
Never mind the brake lights that very realistically appear in your backdrop.
That's correct.
Oh my
God. It's all virtual background. You know how technology and AI is these days. So just.
I'm having a grand old time reading Blatherings by Douche Canoe and very gay Nick Ricada voice, and having a good time at it.
Excellent.
And I'm hearing myself in your Bluetooth.
Well, because you're not on Bluetooth. There's no such device attached at the moment.
Oh. Well, I
So
hear it either
I'm
way.
just popping in temporarily. Are you wrapping this up, or is there going to be opportunity?
Are you kidding? I can go for another 130 pages.
All right. Well, here's just the preview of me coming in. I'm going to drop, and as soon as I am in a different locale, I will join the studio proper and start drinking because I'm very thirsty.
Didn't you just come from dinner?
Yeah, but I only
You're
had one.
thirsty again.
I only had one. So.
Wow. Well, yeah, you are driving. I mean, not driving. Sorry.
No, I'm not driving. No, of course
Not
not.
driving. We are not driving. We are not
No,
driving.
we're not driving.
He does not have his hands on any device.
No, of course not. I wouldn't have.
Danny says, did y'all see that body cam of the lady who signed into Zoom court, obviously driving and lying about it? There are so many of those that I've seen. So many,
Yeah.
Danny.
Yeah, and thankfully this is just, echoes this little corner of the internet here. It's not Zoom court, even though I'm sure I'm going to be judged all the shit because of it. But, whatever.
No one
He judges
demanded
me.
you appear. At least not yet. All right, well, you go do your thing.
Yes, I'm not dead. That's just what I wanted to tell your audience. I have not
Well,
died.
okay. Well, I thought maybe you were having a nightcap and dessert somewhere.
Well, I was tempted, but I definitely wanted to make an appearance. So.
I mean, it was possible, Twink number 2 just showed up out of the blue and you were just indisposed.
Don't tease me with a good time. That's rude.
Yeah, I know, especially on a Sunday evening.
Right? This is the Lord's day.
Well, I've already been swearing. What can I say?
Yeah, all right. Okay, I will be back.
Okay, he'll be back.
Bye. All
right. We'll carry on without him because there's more. We're only at page 18 of 144. And I wish there was mango custard involved, but he I don't know. He doesn't have mango custard in his not vehicle driving. Oh, let's see. That allegation is false and defamatory. Okay, next. When I first appeared in Owens v. Eckerd in late March 24, the case had been pending for nearly 8 months, and the paternity aspect was effectively over. When I appeared in this case in March of 24, Miss Owens was no longer pregnant and was not claiming to be pregnant, because she never was. Therefore, her paternity action was moot. See, he's just going to relitigate the whole goddamn thing. Yes, I'm going to swear a little bit. Sorry, Alex. Sorry, cousin Alex. A little taking the Lord's name in vain here, because that's what douche canoe does to me. This is why I have to space things out a little bit. I'm not sure. I am not sure I could do what the new people to the scene, like the Amazing Bacon Bears and such. I'm not sure I could do all of it on a semi-daily. Well, many of them are doing daily things, getting caught up, and some of them are getting close to stuff in real time. I'm not sure I could do it without going crazy. I'm not sure I could. There's just so much, and there's just so much craziness that I think I would just go. I'd need full-time therapy, full-time. Marcus says, Danny just described half of my favorite Law Talk with Mike videos. Oh. Hey, that's how all this started for me, folks. Law Talk with Mike and Who's Your Daddy. I've thought about going back and rewatching those as sort of a watch party. The early days of this case, when I was just a newbie to talking about this stuff. Okay, carrying on. We're stalling for Jeep Daddy time is what we're doing. See, I told you. That's why I saved the long pieces of paper for the next, for however long it was going to take him to get home. When I appeared in this case, there were only 3 issues remaining to resolve. First, Mr. Woodnick's motion to compel. Second, his motion for rule on sanctions. Third, his motion for relief based on fraud. The motion to compel was resolved just days after I entered the case. Because the court granted Mr. Woodnick's motion after denying my request for an extension of time to respond. Although I believe the order granting the motion to compel was obtained by fraud on the part of Mr. Woodnick. Oh, now we're going to accuse Woodnick of fraud. Oh, you pig. I nevertheless complied in full with that order the same day it was issued. How can you order grant? What? That doesn't even make sense. Okay, we're not gonna rethink about this stuff. We're just not gonna do it. It's a waste of brain cells. Oh, let's see. What else? Ms. Wing says mango custard, in which case I go, mango custard. I do have some ice cream in my fridge I bought today. I may have a little treat myself in a little bit. Let's see. Danny says, you do a lot more than many can handle. From what I could see, you were the only one who covered Randaz's entry. Nick Starro and MLS didn't even know he was on the case. Oh, yeah. Jardada Akshani, I took a leaf out of Gingras' own book and asked Google AI if a DVRO invalidates a subpoena. No, a subpoena is generally not invalid just because. Yeah. Well, it was ridiculous. Just as the appellate courts said about so much of David's stuff, they're not based in law or fact. And I think that's just how he operates. See, DVRO is in place between litigant and witness. Legal systems view the courtroom as a safe zone, and the court's need for evidence often overrides the restrictions of a protective order. Yes, that is generally how I understand it as well. As for the issue of Rule 26 sanctions, Mr. Woodnick withdrew that motion on April 3, and after I informed the motion was groundless because I filed it without... Okay, you know what? We know what this is talking about. I'm going to skip a few pages. I'm feeling optimistic. Let's see if we can... we talk about sonograms and Southwest Medical Imaging. Submission was not news. During a deposition, Ms. Owens admitted to altering the sonogram. This happened weeks before it was first retained. Barely. It also happened when they retained their expert witness, Dr. Michael Medchill, Mr. Dribble Before You Shoot, where Laura Owens sent David an email saying, oh, maybe don't include this thing because I don't want to be perjured based on him not believing me. He was aware. He was aware, and yet they still presented it. Although Bar Counsel clearly believes the sonogram was of the utmost importance, that I should have spent endless amounts of time and money trying to verify it, this view overlooks a key problem. Sonograms are not relevant to a paternity action. Au contraire, mon frere. You can't just rely on pea sticks for paternity, you douche canoe. In fact, a sonogram cannot be used to establish paternity under any circumstances. Okay, I can't relitigate the relitigation of the relitigation. I can't do it. I can't. Just keep moving. Genetic testing, Arizona law, sonograms. Furthermore, basic level, Bonnet was first retained to represent Ms. Owens. The only real pending issue was Ms. Owens had any reasonable basis to think she might, it should have been, think she might be pregnant with Mr. Eckert's child. Children! They were supposed to be twins, you dumbass, at the time the case was commenced. Even if Miss Owens was never pregnant at all, or if she was pregnant and Mr. Eckert was excluded as the father of DNA test, those circumstances would not warrant sanctions as long as Miss Owens had any reasonable basis to think she could be pregnant. But she was not. She did it by fraud. Trish Jacks's mom, hi TJM, says to Danny, I saw that, and she continued to say she wasn't driving as she exited the vehicle from the driver's side. Lying to a judge is never a good thing. Yeah, it's funny. I've seen quite a few of those. Miss so-and-so or Mr. so-and-so, are you driving? I saw one with, was it Simpson? I think it was Simpson. He had one, and the guy was like sweating. It's like, oh shit, I've been caught by the judge, and I was driving, and I just pulled over and parked, and oh crap. And I think he had a show cause, and got in troubles. Sonogram was important not because it's important for her paternity, it's important because it's evidence of her fraud and bad faith litigation. Yep. Sonogram validated might be relevant to show that Miss Owens was pregnant with someone's child. This evidence was ultimately minimal importance because she was never pregnant. Specifically for Stephenson, Miss Owens had multiple positive pregnancy tests. Those are not conclusive. I'm aware after the trial ended, new evidence was obtained which may call into question the accuracy of those positive tests, but I was not aware of any such evidence at the time of trial. Are we talking about how the Maricopa County Attorney's Office found that she went to Inova Med Spa and received shipped to her door HCG injections ostensibly for weight loss? One wonders. This goes on to talk about the P tests. I don't care. We've covered all that stuff before. Email, let's see, from Clayton Eckert. Oh, talk about the BJs, blah, 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 blah. Mr. Eckert's admission, he personally saw a positive pregnancy test and that he had sufficient sexual contact, blah, 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 rubbing and rubbing. Oh, and look, there's the altered belly photos. And look, there's the Twig herself. We should call her Twiggy, only because Ricada said that. I meant to have that queued up. The poster child for, shall we say, eating disorders. For fraud, eating disorders, and, yeah. Oh, look, you're back.
I am.
All right. Cheers. Chink, ching, ching.
Ching, ching. There we
I'll
go.
clank my lid.
That'll work.
I'm.
So what I missed? What's happening? What's going on?
Oh, more than I dare to talk about. I'm at page 23 of 144 of Dushkinu's vomit on Randazza, Mark Randazza paper. I don't know that I want to do this. Most of this is going all over Owens v. Eckert again. I can skip further ahead. Let's see. Laura Michelle Owens, Glenn Zeman, Barrow concussion and brain injury center.
Who's got the brain injury?
I can't do all this stuff all over again. I just can't do it. As Danny says, I hope Nick sends him that being Randazza. The clips of Dingus totally butchering the First Amendment. I hope so too. I'll cue that up momentarily. So Mark Randazza, First Amendment expert, bully attorney to the stars, is limited representing David in his bar disciplinary stuff. And Nick Ricada and Megan Fox in a 9.5 hour extravaganza over 2 nights.
Oh my God.
Go over, they cover Hey Rob's injunction hearing. We covered that, when it happened.
Oh yeah.
And Ricada absolutely roasts the ever-living hell out of both Dingus and poor Rob's ineffectual attorney.
Ugh.
And on the second episode, which I watched just yesterday and again partly today to cue something up, Ricada says, David just absolutely butchered the First Amendment. I should send this over to Randazza. I should clip this and send it to Randazza and just show him how much of a loser he really is. That's about how Ricada talks. It's kind of funny. I was telling everybody earlier, I can only watch Nick unlimited amounts because he reminds me too much of X number B.
Oh, yeah.
And they spend a lot of time on Ricada's chat and channel talking about penises and micropeens, and it's like, And poor Nick has the same sort of collateral damage with substance use that X number B had. It's like, you know what? This feels a little too close to home right now. Even though he is entertaining as all get out, and the guy does not filter much. It's very entertaining. He's not as greasy as Howard Stern, but he'll let it fly. It's funny. It's funny to me. I guffaw most of the time.
Yeah, when you're not like re-traumatized.
I know, and they have sort of similar looks. I mean, Nick's got darker hair, but tall and lean and lanky and a big nose. It's like, oh gosh, this hits a little too close to home. Just a little too close. But it doesn't keep me from watching the guy when he's absolutely raking David and Laura over the coals.
Well, yeah, because they kind of they deserve it.
I know. Well, and what Nick was saying about the poor representation that Rob had in defending him, it's like the guy's like cupping his balls. Does he even have any balls? He's not fighting for his client. He's doing nothing. He's sitting there doing nothing. 9.5 hours. 9.5 hours in 2 parts. 5.5 hours in part 1. 3 minutes 58. So I'm rounding it up to 4.
Jesus.
9.5 hours going over barely 2 hours of video. It was just wild. It was wild, and it got me all fired. Yes, Amy says the Jeep signal went out and it worked. Got a phone call and had to step away. Yeah, well, that's all right. Let's see. Amy also says next chat can be really cringe. Yeah. there's a lot of straight guys who just want to see big boobs on trampolines and that kind of thing. Oh, we should put Megan's head on trampoline. I mean, some of them are just they're D-bags.
Well, and that sort of personality, if it's anything like X number B, it tends to attract a certain crowd, shall we say?
Yeah. I mean, that's very entertaining. High quality stuff.
Yeah.
Nick's got 400 something thousand subs, so he's doing fine.
Yeah, thanks for great YouTube.
They call him the godfather of LawTube. They say he started it and coined the term, so good for him.
Good for him.
He can't practice right now because he got in trouble for the proclivities, but that's what happens.
Yeah, that's what they do.
He's waiting it out. Hopefully, he's doing all the things. I hope he's doing well in recovery and rehab and all that stuff. Things my ex failed on miserably. Multiple times. Yeah. Numerous times to count. But my ex was doing a lot harder stuff than Ricada, who was doing, fluffy white powdered sugar, as I understand it.
Oh, yeah. Okay. All right.
Yeah.
Little bit of that. A
little snow and blow. Yeah.
Yeah.
Well, he's got nose cam on. It's kind of a joke. It's like, I've got my other camera here, so just to show that I'm keeping my nose clean. Everybody.
Oh, it's funny. Gag me, Jesus Christ.
He does. He's got quite a beak. We'll play some of him in a little bit because I want to play the section of him roasting David and saying, "Oh, I'm going to send this to Randazza." I hope he does. I really hope he does, because it could very well be that Randazza might drop kick this. It's like, oh, you call yourself a free speech attorney, David, and you can't even get it right. Oh, I need to leave this. I need to get away.
Yeah,
you're on your own, David. Figure it out with a bar. Go away.
Yeah. Well, that's just the kind of type of person that David is. He's the type that you're motivated to say things like, get out of here, bye, leave.
Yes.
Danny get the hence, Satan. I don't know, something.
Get the hence. Oh, did you see that little thing I sent you earlier today from Facebook?
No, I haven't seen that yet.
Oh, okay. I guffawed. It was entertaining. Speaking of Satan and certain Mormon things, I'm trying not to digress into Mormonville and people being sued by the Mormon Church. I'm avoiding it like the plague right now because it's just too much. Danny also says, I appreciate that Nick owns his mistakes, unlike certain other attorneys. Okay, fair enough. I just hope Nick is doing all the right things, because if I were Nick, I'd be afraid of Megan Fox kicking my ass. That's what I would be afraid of. Because she would. She totally would. She may have. Minnesota's not too far from New York. Let's see. Gumbatron says his license issues are due to missed CLE rather than his other issues. CLE.
Continuing education, something or other?
Nick's stuff. Sorry. We're talking about too many attorneys. Trish Jackson's mom says Nick started his CLEs this week, I believe, and he has been 1 year sober from all the extracurricular activities. Good for him. She did when he was going downhill. Yeah, I remember. She was distraught because his whole world was collapsing. I think there was body cam footage, and other people in the LawTube sphere were just raking the guy over the coals.
Dang.
I mean, when you get caught doing the crime and the time, and you're going to have to endure a little bit of internet abuse. That's just, I don't know. How the mighty fall, and when you fall that far, people saw him wasting away live. He was doing blow live. It got him in trouble.
That's bold.
That's how far it went. Not only was he plastered on lives, he was doing it just off camera, and people figured it out. It's like, okay, well, he didn't keep anything a secret, so you just have to pay the piper there, and you work on your redemption arc.
Suppose so.
But he's funny. He's hysterical. You'll get a kick out of him. And he's good at being. I'll lay it out there. He's good at being misogynist and racist and all the most careful of ways that say the right words without pissing people off the wrong way.
Oh, all the dog whistles.
Funny.
Yeah,
he's great. Okay. He's great.
Yeah.
I mean, he is entertaining. It could get me in trouble saying that I find him entertaining. I should be outraged and want to cancel him. No, because I believe in free speech. Even speech I disagree with. Which is why, the whole thing with Rob was such a struggle, because it's like, okay, yeah, I don't agree with the guy and some of the stuff he said. So what? I don't have to watch it. Neither did anybody else that was raking him over the coals. but he still had a guaranteed right. And Nick talks about this ad nauseum. There was really
For
nothing
9
he
hours,
said,
apparently.
because harassment is an action and not words. Harassment is the action of doing things. Yes, it can involve words. It can involve delivering words, but words themselves are not harassment. Was the shorthand of 9 hours of watching, and just all of Nick's going on and just raking everybody over the coals. It was very entertaining. It was very quick 9.5 hours.
All right.
In the meantime, let me see. Is there anything interesting in this? I'm going to skim through this because we're just talking about Owens v. Eckerd until we're blue in the face. And it's probably going to go on for dozens of pages. See, to my knowledge, the bar has disclosed no evidence, no legal authority that shows any argument I made or position I took in the appeal was frivolous. Well, they already declared it was meritless. Okay. Let's see. Statements regarding Judge Mott. Is there anything interesting in this? I've not previewed this at all.
I wonder if he's just going to rehash everything that we have gone over.
That's exactly what most of this is. Oh, Judge Mott, Judge Kidd. I mean, it is. It's all just relitigating everything he's lost. I'm just going to skip. Even though it says Randall's a legal group all the way up and down it. This is all David stuff, I'm quite sure of it. Here, Mark, can you put this on your letterhead for me and submit it like you're representing me? Thanks, bro. Judge Mata, Family Raw Owens. Mr. Woodnick didn't do this. Mr. Woodnick didn't do that. Woodnick. Who has the time to write all this shit? That's what baffles me.
It's a lot. I just kind of have to wonder if
He has
there's some
nothing else
AI
he's doing.
assistance.
I wonder. I can't help but wonder. Mr. Howe, Judge Mata, Mr. Howe, Judge Mata, Mr. Howe, Miss Owens agreed to pay nearly $2,000 for an expedited copy of the trial transcript. Good God, why is it so expensive?
Wow.
Sounds like a scam.
Meh, maybe.
I mean, is that what? No, because wait a minute. I think Clayton's side paid for the court reporter. So I'm trying to think, why would it cost so much to get a transcript? I mean, it's not like it's a million pages at $2 a page. I don't know. I don't understand the pricing.
I mean, the AIs are really good at doing transcripts. I mean, hell, I can stick my phone next to, the back of a room during a lecture, and it can get a transcript churned out from the audio.
Yeah. Amy says, I didn't know who he was, referring to Ricada, until Megan introduced him to the LO case. I couldn't believe people were impressed with him, but I didn't know he had a DRUG problem at the time. He's much more tolerable now. What I've seen of him lately, I saw it. I was actually watching him. I wasn't subbed at the time, but he was talking enough about other things I was interested in. I was watching the decline, and I saw some of those lives, and I went, oh, this is bad. This is really, really bad. And it's live, and people are probably recording this. This is going to go bad for him, and it did. It did. I think he spent a little time in the clink. I think that's what I remember. After they busted him on a warrant, he spent a little time in the clink and got out. And rumor has it he lost his kids. So it's a whole big process. It's just sad. It's sad. Wow. Henrietta says, oh, I saw what he did on a live. OMG, I cannot go back. Yeah, exactly. Yeah. No thanks, MK says, night all. Sounds like they're leaving. Good night. Catch dressed on the PCB. Amy says, did he? That's what I was seeing in chat and some other places. He's probably not going to address it directly. That's his prerogative. But typically when you have that kind of problem, that's not uncommon. Especially when both parents were busted. So, yeah, it's rough. It's not good for the kids. It's so sad. All right, moving along. Let's see. I'm just going to keep skimming. We've got more color inserts, like you're not supposed to do. And then we've got a signature. So that's the end of, oh my God. Okay, what's the next 100 pages? I'm afraid. Exhibits? Disclosure. Pursuant to Supreme Court, supplemental disclosures, in addition to other matters, respondent discloses following information response. Do you see this? This is like inserted. Do you see how it's darker at the words?
Oh, look at that.
Look at that. Something has been changed in
And
this.
it's not even just like, because I'm zooming in as well on my side, like the word matters doesn't
Is
have
not, yeah.
that background on the text.
Oh, how weird. This is very interesting. Probably because.
Oh, look at that sloppy blocking on the front of that. This argument appears,
Yeah,
blah, blah, blah.
right there. Oh, I don't have a cursor that shows up. See, does it?
Yeah.
It doesn't highlight, does it? Yeah. Oh, that's interesting. It doesn't highlight it. Huh. Oh, this is very interesting and suspicious how this was created, how this document was generated. Yeah, there's a lot of it. So maybe this was some cut and paste.
Yeah. It's kind
for
of my
whatever
suspicion
reason.
there a little bit.
See, even the footnote. Well, wait a minute. Maybe not. No, the footnote does not have it.
I don't see it.
Interesting.
Huh.
Interesting. I was trying to dig through this for all of the anti-slap stuff that David was going to use or claim, because that's, Randazza being, free speech extraordinaire. That's what I'm looking for. But we haven't gotten there yet in 100 pages. Well, we're not 100 pages yet, but 46 pages. As a lawyer with many years of litigation experience, respondent is very familiar with the rules for both sealing and protecting. Now we're saying the same thing.
This is more redundant.
Yeah. We're saying the same thing that happened on the first couple of pages that David already went through in his affidavit.
Oh my God.
And here, after reviewing the file on his record, respondent concluded the court had not issued any, so now we're just repeating ourselves. Well, hopefully this pisses off the PDJ right proper. Wound bumps. Oh, look, more of the same pictures. I just scrolled past these pictures. Oh my God.
And you're not supposed to put color photos or things and shit like that. I mean, didn't he get his hand slapped for that once?
Yeah, the PDJ said we put them as exhibits, but I do it all the time. Well, maybe they'll get pissy. Respectfully submitted 2026 David S. Gingras. Okay, so now it's got another one with his signature on it.
More colors highlighting. Okay. More color.
Certificate of service. Let's see, was that March or April? Yeah, March. Exhibit A. So what are we doing? Oh, there's a lot of blank pages. Why are there so many blank pages? That's a waste.
Like Exhibit A was completely blank.
Superior Court. Let's see. Non-party David Gingras motion to file leave under seal. What is this about? What? Is this a reference case?
Supposedly an exhibit.
Oh my God. Yeah, it's an exhibit, but what for? Sealing. Probably about sealing records. Yeah. This is a case I worked in. It's about I know how to seal records. Oh my God. Who cares? E-signature. Skipping. We're at page 66. Another different thing. Oh, this is some of the stuff he's done, I think. Or more of the stuff, right? Media, plank, no, oh, maybe not. Protective orders. This is just referencing protective orders. More blank pages. Wasted paper. Holy Lord. Boy, someone did a
bang up job with the paging.
Did it not load properly? Oh, whoops. Oh, what's it doing? Okay, my paging's getting weird. I was at page 66. Yeah, there's a lot of blank paper. Exhibit B. I skimmed through that before. I hit the wrong button. Oh, okay. It's having difficulty loading too. Yonk. You know what? Maybe I don't care. It's so big, it's chunking up loading it. Yikes. I mean, sometimes I like the exhibits. Oh no, we got exhibits for the exhibits.
Oh my God.
God,
they just they attached a whole sets of cases and stuff.
Love notes between David Gingras and Greg Woodnick. This could be fun.
Oh, this might be fun.
Yeah. From David Gingras, Thursday, April 4, 2024, to Greg Woodnick, CC Isabel Rainey, and Maribeth Burrows. R.E. Owens via Eckerd, request to meet and confer. Greg, thank you for the email. Your words are noted. I'm obviously a passionate person, and my words sometimes reflect that. I do my best to remain professional with you. Yeah, right. I'm allowed to be upset when I see something that I think crosses the line.
Okay.
He thinks everything crosses the line if it's not in his favor. I don't want to escalate the debate, but as much as you may have concerns about my words, I also have concerns about your conduct. Lying to me and or lying to the court are much more serious problems than me tweeting comparisons to an MMA star. Because he references himself as the Conor McGregor of litigation. As for the other points you mentioned, a few comments. First, I'm aware of no court order that would stop Laura from publishing her own medical records. Yes, I'm aware there's a minute entry order dated 2/21/24 that says, among other things, no party shall disclose outside of themselves any medical or other documentation between the parties. I've talked about this 3 times already tonight. I'm not going to read this. Let's see. Laura does not want to fight this battle with you guys. She would strongly prefer to stop all the insanity immediately today. Like, yeah, she wants to be let off the hook.
Right. She take no responsibility.
Never.
Like she. Yeah. No.
Danny, we are on the 144-page filing document. It's the affidavit of David S. Gingras in support of respondent's motion to dismiss summary judgment. Redacted. And it's a PDF. See, now that I've had an entire 10 days to catch up, I can see why people like Dave Neal would not want this, because he is making money by exploiting the situation. It's a dream for him. Oh, please. This case has provided Dave with endless content, and when you are a social media guy like Dave, content is literally the same thing as money. I remember David made a video
only wish
where he said other content creators he personally knew, they were making hundreds of thousands of dollars, and it was an addiction. It's like, well, who were they? Who?
Yeah.
Let's give some names. It's too bad that he is likely going to lose a lot of money when Laura sues him, but that's a discussion I will have with him separately. See, there is proof. There is proof that what Laura said in the hearing with Hey Rob, that she didn't sue anybody else because that was a question. This is proof that they were going to sue Dave. They had threatened it. Dave had to get a lawyer to fight off an injunction against harassment against him. She perjured herself in that court yet again.
She's really good at that.
Yeah, she is. As well as taking throat loving twice.
Yeah.
And a nap. Oh, let's see more from Greg Woodnick to David. Well, I appreciate your right to speak on all issues. I'm deeply uncomfortable with the tone you are using in emails to my office on Twitter and in your blog. Oh, so is this the original email?
This is his response. Like that one would be the original.
Yes. So the one below is the original.
Yeah.
Got it.
And that's probably not because it still has RE in the subject line, which probably means that there's more.
Yeah. Well, we'll keep scrolling.
Yep.
These are old news at this point.
More. Yeah.
April 4. Let's see. This is April 4, 12:56. This is April 4 and the first thing in the morning. Prepare to be surprised, but for once, I'm not going to be a jerk. Wow.
Yeah.
They even have to say that. I'm
going to show you're normally a jerk then?
Okay. Sometimes. I'm going to show you can be reasonable sometimes. Shouldn't you be reasonable most of the time, unless you've got some sort of psychotic issue?
Well, no comment.
Oh, my God. Oh, my God. Because you've already deposed Laura, and because of so much she discloses may raise big questions, what if we were to schedule a conference call? Blah, 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 blah. Okay. Another exhibits. It's multiple exhibits. Laura Owens, improper. Michael Maricini. Ron Owens. Restraining order against Michael Maricini, 12618. Criminal protective order, blah, 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 blah. This is a court order. Okay, this is Maricini stuff. See, I mean, this is just old news.
It's like this
David
feels
J.
like it's like the one document that just like is everything
ends.
trying to cram into it.
It never ends. Well, it's not even everything. That's the scary thing. Mr. Gingras, my client will not be testifying. Randy Supalak. Okay, so that's stuff that the respondent's first supplemental disclosure statement. What is this? Respectfully provides the following supplemental disclosures. Persons who have given statements. Enclosed is a thumb drive which contains 14 video recordings, including statements made by respondent, Ms. Owens, and others relating to the Owens v. Eckerd litigation. These videos may also be downloaded here. Videos for Jim Lee. Oh, we took out the linky link. That's not nice.
Yeah, that's boring.
Crying on Facebook. That's Laura Owens. Judge Mata's dad compilation. Mike admits he was never going to testify. Untitled video. Probably some of his defunct YouTube stuff. Respondent's factual and legal basis. I'm not seeing any anti-slap stuff yet. This is all... Oh, Laura Owens sonogram. Ha! Wow. Assume Laura asked ChatGPT to create a fake sonogram. Oh, didn't need to. She used real ones. And then had Fiverr do things, and then she did things, and yeah. Okay, why are we relitigating this? You lost. Move on. Sit down. Denied. Sit down. Exhibit F. All the way back to 2023. Clayton Eckerd stuff. Talking about rubbing up and oral sex. Oh, pregnancy test. Now we're going to go through all the HCT tests. Oh, God. Really? Now we got redundant pictures. They shot themselves in the foot allowing this. Well, kind of. Code inquiry, diagnosis, clarification, phone message. Laura Michelle Owens, clinical semen. I apologize that you haven't heard to schedule that appointment with the epilepsy clinic. I definitely understand the urgency and mail delivery status. Blah, blah, blah. Dr. Seaman. Huh. I went to Planned Parenthood while I was visiting California last week because I wanted to see if I could get pills to have the option to terminate pregnancy in a state where I wouldn't be required to look at the ultrasound like I would need to in Arizona. Really?
Yeah, that was kind of an anti-abortion thing that they were doing a long time ago before they struck it all down. Like the idiots in the robes struck it all down. But yeah, it was like the way to make the guilt part of it of like, don't do it, because look.
Well, we know that she didn't visit Planned Parenthood.
Yeah.
To get scanned by anything.
Yeah. More lies.
Let's see, they did perform a scan while I was there and confirmed that I wasn't just 6 faulty at-home pregnancy tests and 1 inaccurate urgent care pregnancy test like the father of the child had hoped, and that it is, in fact, a real pregnancy, just like it was real cancer. Oh, my God. Uses the same words, even. Real pregnancy. Real cancer.
God.
She is a one-trick pony. I was told there was actually something on the ultrasound. I was lucky enough. It's just more of a fabricated vomit.
Mm-hmm.
Respondent's factual legal basis. Blah, 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 blah. I'm still not seeing any anti-slap.
That's the same thing.
I want to see the anti-slap stuff. I want to see the First Amendment arguments. I'm not seeing it. Just a lot of douche canoe signatures.
We're back to Exhibit A again? The fuck?
I know, it's a mess. The whole thing is a hot mess. Ludson, some other case. 2024, Judge Mata's division. This is the Mata whining. I wonder if he uses email trackers the same way Laura Owens does in the image.
I'd be suspicious as shit.
Yeah. That was supposedly how Laura Owens was tracking Clayton Eckerd, was every time he read something. Oh, I saw it. He read something. I need to email him more. Let's see. Okay, that's the bottom of the document. Okay, God, that's enough. So you want to go? You want to go to the memory hole a little bit? This could be fun for you.
Oh,
This
let's.
could be fun for you. This is Colin Farrell, and Douche Canoe was involved. I think his raison d'etre, shall we say, in taking this case was he likes rubbing shoulders with people of status, and, some degree of celebrity. Oh, you're Ron Owens. Oh, you're famous in San Francisco. I've heard of you. Oh, you're Laura. Oh, we want to help you, Miss Daughter of Ron Owens. He was involved in Colin Farrell's whole thing, which I don't know if I was aware of that or not, but we'll play a little bit. This comes from A&E. I think did I include the link? I think I did.
Position. He threw his.
Is there audio?
Yes.
Oh, maybe I should back it up a little bit. Come on, give me what I want.
My boss, Maria Speth, and I flew out to New York with my client.
His voice.
And we met Colin Farrell law firm in a conference room on Easter Sunday. During Colin Farrell's deposition, he, through his lawyer, was trying to make an argument that this would be so devastating to his career. But then he was just in some movie playing a guy that was exactly this kind of guy. So does it really hurt your career that much? Our job was to kind of attack him. In fact, I remember preparing for it and going over his Rotten Tomatoes page, going over all his old movies.
David makes some, sort of off-the-cuff admissions into this case he was involved in, which are suspicious to me.
And we were trying to emphasize the point that the sex tape was not that out of character for what he was known for. And we were trying to show that if this video got out there, it wouldn't be devastating to him. After a couple of hours of back and forth in this deposition, I think both sides just said, why are we doing this? Colin Farrell was a really nice guy.
He's a decent looking guy too.
Yeah.
At least
I had a crush on him.
Yeah.
I think that was part of him being Irish. I think that was part of him being just a gentleman. He was a gentleman. He emphasized over and over again, this is just private. This is just not something that he intended the world to see. And it's pretty hard to look a guy in the eye and say, I don't care that you feel that way. He had a right to feel that way. It was his privacy. So I think we kind of broke Colin Farrell down a little bit. And I think he kind of broke us down. Maria Speth and Marty Singer went into a closet, literally in a closet.
That's professional. Why a closet? Was there not another room they could have a private conversation, an attorney to attorney?
I guess not.
That's weird to me.
It chatted for about 10 minutes and everyone was sort of whispering. They came back and an agreement was reached to just settle. And Colin Farrell did yell at me, by the way, in the middle of the depot.
Oh, no. He probably deserved it.
Because outside the building, there were a bunch of paparazzi. And he wanted to know if I had leaked the location because nobody knew the location of the depot on Easter Sunday, of all things. I'm not going to try and do his Irish accent. Gingras, did you do it, man?
Then he go ahead and does it.
Yeah. No, I did. No, I lied to you.
Did he, though? Did he?
No, if I had leaked the location because nobody knew the location of the depot on Easter Sunday, of all things. I'm not going to try and do his Irish accent. Gingras, did you do it, man?
Did you do it?
Yeah. No, I did. No. I
What do you think? I think it's highly suspect. And then he grabs the water and, no, I'm lying to you. Gulp, gulp, gulp.
Gulp, gulp, yeah.
I don't know. Maybe he could be sued still.
Lied to you.
I mean, talk about a snake. Absolute snake.
Well, yeah.
The media wanted to know about this deposition, wanted to know where it was. And my client wanted the publicity. And it was sort of like, hey, well, if we tell you where it is, can you drop our web address in the story? And so I was asked whether that was permitted to release that information. And there was no court order or other reason not to release it. So I approved it. I didn't do it myself, but I approved it.
Huh. Also suspect.
Yeah.
He's fishy, just through and through.
Yes.
But Colin Farrell was absolutely sure I did it.
As he gulps on more water. Oh, that's better.
Yeah.
Come on.
In April of 2006.
And it goes on, but, I thought that was, Oh, there's a little more of him. Let's see. I think then he talks about the dirty a little bit.
About.
The tape did eventually get out. My recollection is a website called Dirty Colin, and they said, we're about to release this tape. Sign up here if you want to buy it or whatever.
Colin Farrell, that is a very memorable sex tape because it was the first time I saw one of those online.
I don't care about all the other details. We just want douche canoe stuff. Let's see, is there anything more? I think he likes this kind of attention.
Engage in sex with her was a very, very big deal for me.
Do you think Nicole Lorraine might have been the one who leaked the tape?
It only could have been Nicole Lorraine. It could have been David Hahn Schmidt. It could have been my client if he lied about doing it. He swore under oath that he didn't. It could have been Colin Farrell's lawyer. It could have been me, actually. Now that you think about it, it could have been me. It wasn't.
Now that you think about
I didn't do it. I swear under oath. I did not release the tape.
Would you tell us if it was you?
No.
Once the settlement had been reached.
He is so not convincing.
No, not even kind of.
Oh my God. Okay, well that's enough of that one. I just stumbled across that because it was being discussed in some other places, and I went, I need to go see this. It wasn't that long ago. This is let's see, what's the date on it? Oop, I've already closed half the thing. Unfull screen it. 6 months ago. That was posted by A&E.
Huh.
So that could have been happening while some of this was happening. For all I know, this recording. Go figure. Go figure. I think he's as dirty as they come. Is my opinion of him.
He certainly is, slimy and icky, and lives up to all of the stereotypes about lawyers.
Yeah, unfortunately. So I've got this other little bit queued up. This is from, I think, was it last night or the night before? This is part 2 of Megan Fox and Rekieta going over Rob's injunction. I've got it queued up where he does a little, after he does a lot of roasting and says he's going to send some of this to Randazza, whose pieces of paper David has vomited upon that I just skimmed over.
Mm-hmm.
So I wanted to play some of this just because it's.
So just the first impression, because I've never really watched any of this guy or whatever, and like the look that he's got going on here, well, the glasses, and then in the suit and blah blah blah. It's like this just kind of strikes me as kind of an ass hat.
Maybe he might agree with that. Even I'm not going to speak for him. When you hear him speak, it kind of adds to a certain perception because he's got a certain, maybe it's the nose, gives him a certain whiny quality to his voice, and it's pitched in a certain place, and it's very interesting.
If he was doing enough blow on lives, then it might have opened up some of those cavities a little bit. I don't know.
I would think because he's as you can see by the nose cam at the bottom, he knows he's got a schnoz. You would have to have some pretty good lungs to snort much up there, I would think. But that's just, I don't know anything.
Well, I don't know what volume it takes to put that sort of thing up there. Yeah, exactly. How much effort it is. Or whether it's like an assisted blowing thing. I don't know. Does he use a defunct CPAP to put it up there? I have no idea. But
with my sinuses, oh my God, not a chance. Not a chance. I would have to drill them out first. But there's a little bit of fun here to be had.
Taste of jokes in court. Jokes are jokes.
For much, much less than what we've heard today. And so I love the First Amendment. I respect the First Amendment. When you get this dirty, you lose the First Amendment rights at some level. It's sort of like a Second Amendment thing. You have a right to have a gun. Mentally ill people aren't allowed that right.
This is crazy. You lose your First Amendment rights? Literally never. You don't ever lose your First Amendment rights, as he's stating. He's saying mentally ill people, they don't get to have a gun. This person doesn't get to have First Amendment rights. That's fucking ludicrous. Yes, Your Honor, misstatement.
Welcome to Gingras 101.
Misstatement of everything. I'm going to clip out this closing argument and I'm going to send it to Randazza.
I love it.
Or I'm going to make him sit on a phone call with me. I'm going to say, hey, Mark, we're going to listen to this.
We're
going to listen to this together. I want you to.
You should, because it's bad. It's bad.
It's actually
so-called First Amendment lawyer. Bullshit.
There's actually something really interesting about that, like legally really interesting about this that I'll talk to you about in private.
Okay. Can't wait.
It's amazing. The fact that Gingras delivered this argument is unreal.
Yeah.
While having Mark as his attorney. Let me just say, like, because
it's surreal. Because David is so bad at making even the arguments of First Amendment stuff. But of course, he's got to weaponize it any way he can so that we can vilify Hey Rob and Laura Owens can get her stupid little injunction. Oh my gosh. Amy is asking, let's see, Amy says the bottom camera zoomed in as a joke. Yes, I know, Amy. I saw it. I was watching it.
And the question that Amy asked, and Amy did ask like a question just before that, like, why are we bashing on Nick? And like, look, I don't know the guy. I'm just doing I'm just kind of having some first impressions here, but like, I have a thing with people who are on streams, whether it's on YouTube or Twitch or any of that wear sunglasses. It doesn't. That you're trying to. There's a shtick there. You're trying to do a thing, and it kind of just makes you look like a douche.
And he would say that himself.
Yes.
It's like, yeah, I'm dressed up like a homosexual. And he talks about his sunglasses, another one. And they talk about, if you find the one with more rhinestones on it, those are mine, not my wife's.
Yeah.
I mean, like he roasts himself, okay? Let's not clutch our pearls too much.
Right. And like, yeah, chat be bashing on him a little bit too, but like the look, it just I fucking hate it because like it just means that you're so fucking cool that nobody's going to see your eyes. What why does that even fucking matter? What is it like the facial recognition and photo stuff that'll look all past that shit. So this isn't you're cool with your fucking glasses on. No, it just makes you look like a fucking moron.
Henrietta says, like the expert. Yeah, expert does that too. It's the same sort of thing. It's kind of the the machismo bro.
Yeah,
kind of. It's not me. And I would have to have prescription anyhow, which costs too much money. I don't need to do it. And I don't have my lights turned up that hot. I just changed the exposure on my camera. I don't like to be bombarded, because you can't see your damn screens. It just becomes a problem. I know some people. It's a look. It's a thing. It's a vibe. Whatever it is. Doesn't matter.
And I know that there's like some like those scammer payback type, not scammer payback itself, but like that style where people will wear the sunglasses. I think the same thing. I'm like, why do you think you're so fucking cool that you have to wear sunglasses like that? Like, I don't know. I know that like, okay, so Danny, fair. It's not trying to hide, but it's just like, again, this is a first impression thing for me right now, and like this is all I've seen. It's just like I'm over it. I'm over it with streamers and sunglasses. You're not that fucking cool.
Okay, now you need to bring your sunglasses on. It rubs him the wrong way. Apparently, it's a Jeep Daddy rant.
Yeah, a little mini rant because I've been here to rant before. Like for the first 2 hours of the stream, I wasn't here to rant about shit. So.
Oh, I don't know that I want to play much more of this because it just goes on forever. And it's all good. It's all worth watching, folks. I highly recommend it. Go over to Nick Recada's channel. I'm thinking Mark Randazzo, wanting to say Nick. And you can watch all 9.5 hours of the whole damn thing, both parts 1 and parts 2. Be prepared. If you need to hunker down for a day, that's the way to do it. I have no idea what Megan's doing. Someone else asked that too. Is she crocheting? Is she knitting? I don't know. Send her a note and ask her. She's probably looking at other things. What could she? Maybe she has to watch her fingers. No, she doesn't. I'm going to make a bad joke. I got to watch my fingers type. No, she might be looking on her phone. Let's see. Do we get anything?
Maybe.
She's looking around.
There may be an obligation for Gingras to not deliver arguments like this.
Oh, boy.
Right. Mentally ill people can't have a gun at all. And based on what I've heard, I don't see any problem with the court restricting Mr. Andreev in the way that it already has. So you should affirm the order. I would actually ask that you expand it. I would want an additional proximity limit where he's not allowed to come within 500 feet of her. I would actually ask the court.
I want a ball gag put in his mouth.
I found that.
He just said he would make that.
There's good stuff. There's good stuff. I don't know how much I dare play this without.
Look, and it's more than just mentally ill people that may have restrictions on gun possession. Like, there's a flurry of different categories of people who are arguably would have their Second Amendment rights, even though that's not an argument I want to get into too much right now. But like, there are other classes of people besides the mentally ill, David, you dip fucking shit.
Oh well. It rubs you the wrong way. Like, what was that joke? Never rub another man's rhubarb.
I mean, not without consent.
Yeah, not without consent. Don't just rub things. That's how this whole mess started. This whole thing started with rubbing the wrong things, or swallowing the wrong things, I guess. Yeah.
If you swallow the wrong thing, you might have throat twins. Just saying.
I am working on a special best of these 2 episodes of 9 hours. It's turning out to be a daunting task. Clipping out all the highlights of all of this time of these 2 roasting David and Rob's poor attorney who stands in the fig leaf position way too much and just doesn't have any. Yeah, it's my God. I was getting irate. I was telling this earlier at the beginning of chat that I was getting so irate listening to this all over again. It's like, okay, we'll touch on this a little bit because Rakeda and Megan just roast the hell of it, and it's worth the watch. And you can hear what Nick, as well a suspended licensed attorney, as he says, actual criminal, still suspended, mildly pretty.
I mean, he's still good. I mean, he is mildly. I don't know all that facial hair. But
he's tall and skinny. He's probably like on the order of Bruce the Moose in terms of stature. At least that's my understanding.
He might be suspended, but he still has the knowledge and education. I mean, that's not to be discounted, certainly.
And Amy hit the nail on the head here, or the hammer, whatever. Still can't believe that lawyer charged Rob $30,000. No one can. And Megan said, "Don't pay it, Rob. Don't pay it. Negotiate it down," because it was the most horrific defense job I think many people have seen in a long time. It was abysmal.
Hell, I could have put up a better defense than that guy did, apparently.
I think a number of non-practicing attorneys could have done it. He didn't argue anything. He didn't defend his client. He just asked some limp-wristed questions to Laura Owens. And, I don't have anything else, Judge. It was sad. It was sad. Let's see. Is there anything else I want to do tonight?
Let's look at it.
I think that's what?
Well, let's look at our show notes here and see if there was anything.
I've hit most of it.
Yeah.
And it's dribbling into the 3rd hour mark, and I want to have just a little ice cream sample before I call it an evening.
Oh, okay.
Because dinner was like 6 hours ago.
Dang.
I had a crock pot going when I got home, so.
Oh, fancy stuff.
Yeah, a little stroganoff. I did it with ground beef this time instead of beef chunks. So, yeah. Nice little.
Did you put those awful, disgusting mushrooms in there?
They want you to add to it, but I didn't do that. I just used what they give you, and that's, by the time it does its thing in the crock pot, there's nothing left. It just.
Oh, is this like a meal kit or something that you got?
Yeah. It was a whole thing. You get the mix. You get the different mixes, and it comes with some noodles that you put in the last 30 minutes. It's quite delightful.
Yeah, okay.
And right at the very end, you dump in 8 ounces of sour cream, and it's delicious. Absolutely delicious.
And it works when you're holding out on me. I came and I came and visited the cubby hole.
Yeah, much against my desires.
I just invite myself over because I give zero fucks. But he didn't fix me this glorious crockpot thing he's talking about, and now I'm really disappointed and sad. And this is now a new expectation.
Yeah. Well, you know.
Yeah. I guess I can
Maybe
want in one
day
hand and
you
shit in another.
sample and you can hate me even more. Let's see. Danny says, agree, Amy. Some people don't show their face at all. Yeah, it's true. And there are people who have good reason. I will just think of Schnitzel Ninja off the top of my head who don't want to be faced. Because there are people like David Gingras and Laura Owens will absolutely go after any way they can and sharpen their knives and pitchforks and ruin their lives. So there are people that have even more reasons than some of the rest of us do. But that's everyone's prerogative.
Use avatars, use whatever you need to do. That's fine.
And he's certainly done stuff I don't like, but the way people just look for things to criticize gets old. Yeah, fair enough. But that's what people do. And Nick's not afraid of talking about his past. He's very public about it. So for what it's worth. Danny also says, I swear those binders were all the info Rob gave him that he never looked at. Yes, not one of those binders ever cracked open in front of his attorney. And like Megan said, get whatever's in there, get them. They might be useful. I'm curious. Is that where the $30,000 went? Was into a bunch of 4-inch binders? I don't know.
Good God.
Let's see. Amy says he handles a lot better than I ever could. I give him props. Yeah, you know, and that's the thing. When you're in the public eye and you can just kind of take the punches, because the punches are going to come. If and or when you do something that's going to get you in trouble and get you on the wrong side of, the justice system. If you can rebound from that, then kudos, really. Because it's not easy. Some people would just retreat, and that's the end of it. But Nick is
it's a hard road to overcome, right? Like, I mean, some of those crimes and convictions or whatever, it's like it's really hard to come back from that stuff, given the way that some of our society here in the U.S. works. So
yeah. Well, and on the subject of haters, that's why I did an episode on my detractors. I didn't get terribly specific for legal reasons, but I talked about it. It's like, you know what? If I keep it to myself, it just gives them the power and win. So own your shit. It's kind of my underlying thing. Own your shit. If you did something, you can fess up. I mean, if the criminal justice system has already prosecuted you, there's no reason to pretend it didn't happen. So just get it out there. Yeah. Take your licks. And, if you have a good sense of humor, and Nick does, he's hysterical. He's absolutely hysterical.
That's good.
You can make fun of yourself. And if you have any self-awareness, you're going to be able to take those licks, make fun of yourself, roast yourself a little bit, and just kind of move on. It's okay. Let's see. Broccoli says, Schnitzel. Whoops, it didn't. There we go. Schnitzel has done a great job of being private. I have a feeling there are a couple people who know who Schnitzel is because she is very well connected. She is very well connected. I don't know how she does it, but it's amazing. But she's done a great job. If anyone wants to learn how to be secretive, take a note from Schnitzel. Amy says, I just felt like you should clarify to the replay crew that he actually didn't lose custody of his kids and he only spent 2 days in jail waiting to get bailed. Okay, I stand corrected. Things that I saw and read suggested that there was a custody issue, and Nick sort of intimated some things. Maybe I misinferred that, so I appreciate the correction. Thank you.
Sure. And if there's like sources or things to like where we're interpreting things incorrectly here, drop them. Like, let's go. Yeah. The Echoes is not so proud to be to dig in and gaslight. So, and neither am I. So obviously, like, do it. But make sure, like, if you're gonna, like, what I would ask is if you're gonna make an assertion, provide it with some facts.
We like evidence. We like evidence. That's why I don't just I'm not another talking head here just going, oh, Laura Owens is this and Laura Owens is that. No, we've got the damn paperwork. Sure, we'll roast her every which way from Sunday because she deserves it after what she put all these men through, and not just the 3. We don't know the total of the collateral damage yet, and I hope at some point it will come out, the body count she actually has. I think people deserve to know how much damage she has actually done.
Mm-hmm.
Amy also says, I'm not saying he didn't lose them temporarily, but he has custody of them now for sure. Great. Fantastic. Okay. I'm glad to hear that.
Great.
Like I said, I don't know all the deets, but I just didn't want that out there. I believe in second chances. Sure.
Yeah.
And I would say the same thing even for Laura Owens. But Laura Owens, unlike Nick, has showed no remorse. She has showed no reconciliatory action, nor has she had any accountability for all the
Right.
things she has done. Because I don't want to make this just about Rekieta.
Right.
I mean, I'm bringing
And
him up
it's,
because he's funny.
yeah. And
I'm not
and
here to
like
trash
I
him.
will look, and I will appreciate the snark as I'm wont to dish it and also hear it and be entertained by it. The big difference between those types of characters is that Nick owns, like, it seems like he's owning all of his shit, whereas Laura it does not, and
She
is
pretends it doesn't exist.
repeatedly dug herself into these interesting quagmires for herself that have resulted in judgments against her, like in the Eckerd case, and like getting the bankruptcy tossed and all that crap, like and DOJ person
DOJ Jennifer.
Yes, just like
Queen
having a
Jennifer.
fucking field day with those questions. I mean, my God. So yeah, second chances are great. There's plenty of people who deserve them. Laura has constantly demonstrated that she is not capable of, in my less than humble opinion, has not demonstrated she's incapable of deserving of such that. Because yeah,
Yep. Let's see. Amy also says she definitely doesn't know how to own her shit. Does anyone actually think she'll take that plea deal? I'm skeptical.
I still think she will the moment that she's convinced that she has nothing left, no options, no exit, nothing on that side. That's the only time that she's going to do it, and I don't know. I think I got a few chips, not all my chips, but a few of them are on the square of it's going to come to that.
Yeah,
because she's going to burn through all of it, and
the clock is ticking.
Yeah,
the clock is ticking. As far as I know, the date that she can accept has not been extended yet. I haven't seen that. I haven't heard that. So that clock is going to tick off, I think, at the end of the month, unless.
I mean, she's wasting all of her time with. She's wasting all this fucking time, like going after Hey Rob and like doing all this other extra nonsense, filing bullshit bankruptcy stuff. Like, come on,
it's side quest for her, and I think for
I
David.
get the side quest thing, but Christ, if you've got a ticking clock on when you can accept a deal or not, like, come on.
David, can you stop worrying about that bar thing? I need to have something written for this.
Yeah.
I would love to be a fly on the wall because I think those
Oh
two,
my God.
like I played in that clip that I have with the techno music. I talk to Laura a lot. We spend a lot of time together. Yeah, I believe that to be true.
I thoroughly believe that. It's probably the first honest thing you've ever fucking said out of your scumbag mouth.
Yeah. Oh, let's see. Becca, to get out of jail. Yes. Becca also says, wish prison was on the table. Becca, we don't know the details of the plea deal. We don't have that. It's not public. Only the victims, as far as I know, the victims, the state, and the parties intimately involved in the case are the ones that know that information. Clayton did make a tweet suggesting he was disappointed in what he saw, and he talked about accountability and are not getting enough accountability. So to me, I read that as either changing the pleas to misdemeanors as opposed to felonies, and or little to no jail time or deferment or something to that effect. That's how I interpreted it, but I have no facts to support that. But just the disappointment Clayton expressed suggests to me that she was getting away with a slap on the wrist for the plea deal. But the thing is that even with the plea deal, she would still have to plead guilty that she did things in order to accept them. I believe that Laura can't even get that far. She cannot say, yeah, I did things. I'll take that deal, please. She does not want to accept guilt. And everything we have seen so far, she has not accepted responsibility. She will not accept guilt. She will not take accountability for the things she got wrong. Even in her bankruptcy case, where she was doing that weird tap dance with Queen Jennifer. Oh, well, I didn't know the difference between a manager and an owner. Bullshit.
Oh, bullshit.
No. No, I think unless she gets to the point of actually being able to say, yeah, I'm guilty, I did things, I don't think we'll see her take the plea deal. And again, that clock's ticking. And unless the state gives her more time, that clock's going to run out real fast. And so far, the state's not offered her more time, but we'll see. We'll see. We know she will most likely be granted the extension to file an appeal in the Maricini case in San Francisco, so she can try and have another bite at the apple there. But we don't know if that's. I mean, Rachel Juarez suggested that will most likely get granted because that's what happens all the time in those kind of cases. So, and then she's got to wait for someone to help her write it. Ghost write her appeal briefs. Wash them in the laundry. Get those briefs all tight and whitey. Oh my God. Okay, I'm done. I've had enough. It's over 3 hours.
Okay.
Let's see. What else? What else is going on in chat? Let's see. Amy also says I saw a post on Reddit with a ticker counting down the days until the plea deal. Oh, I have not seen that yet. I need to go looking for that. I keep trying to figure out how to do stuff like that on my stream. You know, have little things dotted around, and I don't know how to do that kind of stuff yet. All the videography tricks.
Yep, someday.
Amy also says I'm so worried it says no prison time. Yeah, everybody is. Can't imagine her not taking that though. But then on the other hand, I can't imagine her. Yeah, I know. See, it's a funny dichotomy with her. It's like, well, you'd be stupid not to take the no prison deal. But then if you can't accept the saying,
you have to own your shit at that point, even minimally, and like, yeah.
Because I would expect that part of the guilty plea requires allocution of saying, yeah, I did this at this, that, and time and did that with, you know, that's usually how plea deals work in my not so professional experience. You have to allocute. You have to say you did the things that you're being charged of to take the plea deal, and then the court can decide if they accept the plea deal or maybe reject it, or maybe add more stuff onto it. Let's see. On the latest Love Trapped episode, they read her statement where she said she's going to fight. Yes, they did. Fight this, prove her innocence. So we'll see if she'll admit to making all this up like we already know. Yeah. Yeah, exactly. Yeah. Whenever I hear that, I just kind of go, eye roll. Guilty to me. Done. Boom. I'm over it. Yeah. Throw away the key. I can't say what the Red Queen says because I don't want anybody to misinterpret it. And we don't do that kind of thing in this country. Well, no, that's not true.
Yeah.
I better not be political with what I've seen lately.
Not with all the orange stain everywhere, but, you know.
Yeah, well, that's a whole nother can of worms for another time. But I think that's enough Laura Owens and David Gingras for this evening.
Yes. I've only had an hour of it, and I'm already... You can have your ice cream, and I can go and have a refill.
Uh-huh. So, all right. Thanks, everybody, for joining us tonight for yet another adventurous adventure with the incredible craziness we call...
The fucking douche canoe.
Oh, well, that one, too. Or maybe this one.
It's douche canoe and pregnancy faker.
Yeah, douche canoe and pregnancy faker.
The Gingras fun.
Yeah. Where's that one? God, I got so many pages now.
It's pronounced gin like you drink and grass like you mow.
Yeah. See, Amy also says Brian Kohlberger had to admit guilt for every one of his individuals right there in court. Yeah. What's funny is there's people that actually still think he didn't do it, but Laura has no supporters. Yeah. Isn't it ironic? Faking a pregnancy is a stupid thing to do. Faking multiple pregnancies is even worse.
Yes.
Falsifying medical records to fake that you faked those pregnancies. I can't say chef's kiss. I would, I don't know, rat turds in the pudding.
Yes, probably, yes.
Whatever it is. But anyhow, thanks everybody for joining us. Thanks to all those who gave super stickers and super chats earlier. Thank you so much for that. And until next time, which will be any day now, because we've got deadlines happening in the Owens verse and the Gingras verse. More will happen. So until then, we will bid you good evening and happy Monday whenever it happens for you.
Fuck off with your happy Monday shit.
Yeah. I get to talk to lawyers on Monday. I'm so
lucky you.
Yeah, lucky me.
Lucky you.
Thrilled. Either that or I need to find a new career. So we'll at least give it the old college try and see where it goes.
Yeah, see what happens.
But until then, everybody, bye.